A very good morning to everyone, all the participants, panelists. I welcome you all to the fifth day of our value-added course on IPR and artificial intelligence. Since this is the fifth day, I just hope that you all have been enjoying the past few days of the insightful sessions and the engaging discussions that we have been having. And even today, we have an exciting lineup of expert speakers who will be sharing our expertise, who will be sharing their expertise in the field of IPR and AI. And without a further ado, I would like to extend a very warm welcome to our first expert speaker, Mr. Shambhu P. Chakrabarti. He is an esteemed speaker and holds prominent positions in the field of law and research. He is serving as the Dean of Department of Law at University of Engineering and Management, Kolkata, and is also the Head and Research Fellow at the West Bengal National University of Juridical Sciences, Kolkata. With a PhD in Indigenous and Tribal Rights, Mr. Chakrabarti has expertise in this specialized area of law. And as a speaker today, he will be providing us valuable insights into the topics of data protection and privacy in AI, licensing and technology transfer in AI, and IP strategies for AI startups and companies. Sir, we are delighted to have you as our guest speaker, and we eagerly look forward to your session, sir. The floor is all yours, sir.
Thank you, Priyanka, for and thanks, Richa, also for lighting this.
So I also want to welcome you on behalf of Amity University for taking out time and being here with us. So a very warm welcome to you, Professor Dr. Shambhu Prasad Chakraborty, sir.
I would also like to thank Anna, who was also speaking the other day, to be present for this particular presentation as well. And I thank all the participants to plan their timing for this talk. And I hope that even when I'm not really an expert in this area and domain of artificial intelligence, but being a critique nonetheless, and have been working in the area of law for nearly 2 decades, I think it's important that we also put up questions before the younger people to find out possible solutions and answers. So majority of my discussion today would be based on some questions, critical aspects. Now, since you know that, this is an amazing opportunity also, when I was talking with Minnie, who is also a faculty of your department, I was telling that, why artificial intelligence for us? And she was telling us that, it's important that we take up these issues, especially those people like us who are working in this domain of intellectual property rights. So I'm sure, this 5 or 6 days of value-added course that has been introduced by Amity University will really do well and do good to the participants and definitely increase their value. But as we all know that the ambit of AI and the ambit of intellectual property both have a huge, domain, and it is literally impossible to talk about these two things interacting between each other in this small 1 hour time. So what I've taken for today's discussion is a small area which we all know and which is called copyright and intellectual property. And I would like to test how copyright issues are challenged by artificial intelligence in this presentation of mine. So I would first like to share my screen. I'm not sure whether I'll be able to do that, but let me give it a go. Am I visible to everybody?
Yes, sir.
With my presentation?
Yes, sir.
Okay, amazing. So as the name suggests, it's about copyright the law and artificial intelligence. Now, a few questions that is lined up, as I told you already, to the young students and the other listeners of this discussion. As I told you already, that this is a very new domain of interaction where intellectual property is being challenged by artificial intelligence. So in this particular prelude, I think we still need more information about AI. We still need more, perspectives and what are the consequences of AI and intellectual property, and more specifically to copyright issues. And more importantly, also the unwelcome consequences, we call that ramifications. So at the very outset, let us be united in this understanding that we still need to unravel various aspects of artificial intelligence. So once this unraveling is done, once this demystification happens, we have to come to a conclusion, and the conclusion may be radical in nature, radical in the sense that there are some countries who have taken a very strong, approach towards artificial intelligence. And they say that, no, we're not going to permit that. And there are some other countries who are exactly on the other side of that extreme ladder, where they say that, well, that's not a problem. We can definitely take artificial intelligence, something which is interesting. Now, the two countries that I just want to highlight, which have taken this radical line, is Spain on one hand, which has taken the stricter interpretation, and the Japanese, who have taken the very liberal interpretation. So these are the two extreme ends. Where should we stand? Now, this is a very, very interesting question. And this is the prelude that I want to give everyone here as we move on and proceed with this discussion. But whatever, position, whatever policy that we tend to take in our understanding, we have to understand that there are potential perils involved in either direction, either extreme ends. And even when we are in this very balanced, somewhere in between, we need to be very careful while we take our steps. So let's now move into the discussion. So that was the prelude for you, which talks about that we need more information about it, and we need more information, especially as to what are the adverse issues of artificial intelligence, which are still not, and then we have to come to a position. Now, this particular slide that we have is basically the beginning of this particular discussion. And it begins with a very fundamental question. Now, the question is, how can we promote innovation and further generative AI models while also protecting the rights of creators? Now, let me tell you that if we promote innovation, well, which we all should, as a matter of fact, prima facie, we also need to understand the way by which artificial intelligence works. And as I think, this is the 5th day of artificial intelligence and intellectual property discussion. So majority of the viewers must have already have some basic idea about AI. And with that notion into context, I would like to say that artificial intelligence cannot work suo motu. It needs data. It needs huge amount of data on which the specific algorithm works, and then the output comes up. So without the base, without the fuel, without these existing things that we feed into the system, artificial intelligence cannot work independently. Now, this is a very interesting question for you now. How can we promote innovation and further generative AI models while also protecting the right of the creators? Because now we have two different things in front of us. One are the creators of the original work, and then the big computers on the other. So these are the two things. And both of them are creating. But the latter, the computers, are creating on the basis of the work. if you read the next sentence that I wrote for you, is whose works are the engines that fuels these models, and who must compete now with AI-generated work in the marketplace. Now, this is the dichotomy that I want to highlight as we start our discussion. Now, if we believe that these artificial intelligence innovations are really attractive, really good, it can be commercially, it is commercially viable because it attracts a lot of consumers and customers, then why not, make good use of it? The question comes in immediately is that, what about the rights? What about protecting the rights of the actual creators who fuels with their long-standing work into the system on the basis of which the machine creates those innovations? Now, we are in a position where the rights of the creators are in conflict with the rights of the computers and the rights of these great investments into the marketplace. So with this question, let's come down to this particular case study. I'm sure all of you here who are listening and looking into the screen have seen this before. Very recently, I think a few months back, we have seen a list of these selfies of people, including Mahatma Gandhi, many other people, Luther King. So there's so many selfies that came up, and we all know that this is an AI-generated picture. Now, well, it has takers. When we first saw this picture, I would like all of you to move into that particular moment, and it was a moment of awe because we have never expected this ever in our life. So many, Netaji Subhash Chandra Bose and everybody taking selfies is something unique. And it actually helped. It actually gave us, well, this is something very interesting. This is an innovation that is appreciable. And a lot of people said, yes, it is. We even shared this picture amongst our the friends. Now let's see how this particular picture was generated. Now this is what I was talking about, the input and the output scenario. This is what was happening behind the veil, okay, before this particular picture was generated, okay, before this picture came up. What were the pictures that the computers actually looked into, took into basic things and came up with that? Now, this is a person who have given a picture like this, and then, with beard, change in the hairstyle, change in the smile, all these things started happening. And these are some of the, faces that this artificial intelligence machine created. Now, let's come to the main issue of our discussion. Who took that picture? Who took that picture means, who actually feeded, who actually put forward the inputs. In this picture that we just saw, has there been any credit given to those people who have somehow or the other got a picture very close to Gandhi, which could be, manipulated by computers to create in the form of a selfie? The answer is no. Now, look at this particular picture again. If you look at this particular input, we know that, yeah, this is the man who put the input. And then we can look into, what are the various output that comes up. Even 6 months back, I think, there was another very similar experience that we had, especially those people who are very regular on Facebook. This came up like, how would you look when you are 70 years? So a 20-year, 25-year, 7-year-old guy would definitely love to look at how they would look like after 70 and when they get older. And they put a selfie of theirs or maybe a picture of theirs into that particular program. So, and then the generated program comes up. So this is called the input and the output. So in this case that I just stated, we know about who has feeded the input, who have generated that initial image and stuff like that. But not in this case. Let me tell you this, not in this case. So what is missing is number A, transparency. So the transparency is missing as to who actually feeded the copyrighted work. Because if you look into this particular picture, the input picture is a picture which is copyrighted. Because if you have taken this as a selfie, then it has been taken by your camera. So the person who is behind the camera can own this particular copyright under various copyright rules and regulations. The way that you want to look like, you can change it a little bit. You can modify the lighting, the color. So all these things are creativity that moves into this particular original picture. And hence you are the copyright owner of this particular picture. But how about your picture being taken by somebody else and a picture has been created by the artificial intelligence systems? Now, this is very important that we move into transparency. So this is missing at this moment. Now, since we do not know from which pictures this particular picture came up, the owners of those pictures are ignorant of this particular fact. So don't even know that, the system have taken, the AI have taken their copyrighted product somewhere and have used it in one particular way. And hence, licensing of the work is also missing. So the three things that's missing at this moment is there is no transparency. Number two, hence there is no transparency. We cannot identify who is going to pay. So no licensing principles are not there. Now, who have taken this particular picture from your computer? The supercomputer must have taken it. The algorithm must have forced the computer to take it. So who are accountable for that, for copyright infringement of that? Because anyone who takes someone else's copyrighted product without licensing, without informing, is a blunt violation of the legal rights, the moral rights of the creator. Now, this is a very, very important flaw that I might say at this moment. So when we try to look into how other countries have stepped up to address these three problems, then we come up with one answer that is reflected in point number D, which is the US Copyright Office. Very recently, they have come with this set of guidelines, and it has very clearly stated that copyright protection can only be given to human authorship. Now, this is a very interesting idea, human authorship. So the word human is specifically there, okay? So that means if an artificially, a computer or a robotic generated picture comes up or a copyrighted material comes up, that cannot be considered to be something that has been created by humans, and hence that cannot be the subject matter of copyright. So this is the clear position in the United States of America. Now, there are some recent changes, and I think last month itself, the European Union have come up with some directives with regard to artificial intelligence and copyright issues. And there also, there is a new introduction. I'd like to tell that at this juncture. And the introduction is that anyone who claims copyright and puts up before the Copyright Office the claim that this is my creation, I need to get it copyrighted, then the person needs to fill up a declaration where there are two primary points. One, whether that particular person who is applying for copyright have taken assistance of artificial intelligence. If yes, to what extent? And number two, what are the creative works that they have done, this particular person who is claiming copyright has done in the so-called copyrightable work? So in a narrative, it's not specific, it's narrative. So a paragraph writing on that. So what is happening with this experience that I'm trying to put forward before this audience is that slowly and steadily, the laws are also trying to find out the work that is done by computers and the work that is done independently of artificial intelligence, maybe with the help of computers, by human beings. So the law is trying to demarcate, separate the two things in the best possible way. So that means the law is trying to make things transparent. And this is exactly what I'm trying to make all of you understand, that we are lagging in transparency, we're lagging in licensing. Once the transparency is there, we can move forward to licensing, we can fix accountability. And in furtherance of that, we have to look into how, human intervention, to what extent human intervention has been done in creating a particular copyrightable work. So this is a very important, and I believe this is the most fundamental issue that the law is facing when it tries to look into how artificial intelligence should possibly interact with copyright laws in specific ways. So this is the fundamental issue. And the last point in this particular slide tells that, the board, the copyright board, must take every individual case as a distinctive case basis. So this is a very, very important aspect. And I think, it's a very important step towards transparency. Now, let's come back to my case study. Now, again, the input and the output model is here, and you can see that this is a picture, this is a sketch, which I found, which is there on Facebook, and I've already created. So there's a guy called Pallav, who is a Bengali in Calcutta, but I don't know him actually. I just took this picture, and I found that this picture is very close to the one that has been generated by artificial intelligence. I'm sure, Gandhi will look basically alike in almost all the pictures that is available on the web. But then again, if you look into the eyes and if you look into the various aspects, I think an artist would be better to find out the similarities between the two pictures. But my question is, if the AI generated picture has actually taken this particular sketch while it developed that particular amazing innovation, did Pallav got anything in return? That's number one. Number two, was Pallav informed? Number two. Number three, whether Pallav has been given a credit when this picture was generated, or the person who has tweeted these pictures on Instagram is creating all credit behind this amazing innovation. So this is again something which I think this entire discussion is moving around. How we should treat copyrighted work that are used to train an AI model. Now, this is a very, very technical question. Again, the input and the output. Now, if the picture on the left is a part of the input, then whether law should come forward to protect his copyright. Now, this is a very interesting question. And if yes, what should be the function of the law is in this scenario? Forcing the AI to make a database of the various pictures that it is taking when it comes to this particular generation of this particular new picture, and then intimate them, inform them, give credit to them. What are the various things? At this moment, law is silent on these aspects. So it's important that we think of a policy where we talk about the forcible inclusion of transparency. So the engineers, the computer engineers who are developing this algorithm should be forced, should be mandated to develop a way by which the pictures and the other things are the sources that the AI is taking up. It might go to hundreds and thousands of them. But then also, maybe a mandate should be there so that it can, generate that particular thing to the public and the people who are actually have, spent hours and hours to make these type of sketches. I'll just try to remind those people who are coming from copyright law or intellectual property law background, the sweat of the brow doctrine. So acknowledging the sweat of the brow doctrine is also very important if we have to acknowledge the work of people like this. Now Pallav, as I can see, is in his Facebook profile, is a guy who is a general artist, and I can see that it's amazing. But he's not the modern Leonardo da Vinci of Italy or France, or the best of directors and producers in Hollywood. Now, let's take this discussion to those people who are making their livelihood on the basis of their copyrighted product. Is the law protecting their work? This is the most important question that I'd like to raise here. And if it is not, then it is the responsibility of the law to take care of this particular scenario. Now, there is another scenario that the law should also look and delve into. We come back to this particular amazing, innovative selfie of Gandhi and many other people generated by AI. Can these pictures be copyrighted? Now, why I'm talking about this is that it's not only the artist who has sketched this picture, or the photographer who might have clicked some amazing pictures of Gandhi. But it is not only their effort, but it's also the effort of the engineers and the development of a mechanism by which these amazing selfie pictures are generated. So in that case, in the previous case where conventional photographic sketch and paintings were done, there were also, investments in that particular area. And in this area also, there is huge investment. So every investment needs to be secured. So it is also the responsibility of the law to make a system by which these innovative pictures, these outputs, are also protected under copyright. Now, as I told you a little while earlier in the previous slides, in US, it is not, because the word human is classically mentioned. And it is exactly at this particular juncture where a lot of debates and discussions are happening. Even some of the matters are before the US Supreme Court as to whether this can be altered. Now, if you take into consideration the Indian Copyright Act 1957, you'll find that the word human is not there. The word human is missing, and the word creator is there. So in the Indian context, maybe we can accommodate AI a little smoothly than in the American scenario. So to what extent these innovations are protected or can be protected? This is another important question that I would raise in this particular discussion. Now, this entire, discussion can slowly and steadily be, magnified if we look into the various aspects of inputs. Now, I will not, make this discussion very technical, but I would try to, move into the legal aspects of these things. But just have a look at what the inputs are made up of. A vast amount of data, including copyrighted materials, are fed into a typically generative AI system, which is human-authored work. Now, this includes written work, visual arts, music, and these things, if you look into the legislation, the copyright laws, you'll find whether written words, visual arts, music, they're all copyright protected. Okay. And when these copyright protected are by themselves the subject matter of the one that I spoke about, the fuel towards creation of certain things, and there is no compensation, there is no acknowledgement, there is no license fees paid, there is no accountability for taking those pictures, like the pictures are taken randomly from the website. Say, for example, a person wants to sell some of his pictures on the web, and it's available on the website. The AI, the algorithms, the training is given in such a way that those pictures can very easily be collated and then generated in the form of something, and something comes up. And the same thing goes with ChatGPT. The written words, it never can write anything. It only takes various things and then collate it, then use its sense of grammar and stuff like that, and then produces a set of write-up. So if you cut the fuel, the engine will stop. So the law cannot cut the fuel, because this is something which is very interesting, which is creating something amazing for the people at large. So how we can balance this issue? So this input challenge is a very, very important challenge. Now we come to the second point, the process challenge. Now, the model then processes this data with the help of various algorithms to detect patterns and probabilities. Our foundational principle of copyright law generally requires users of copyrighted work to obtain the permission of the copyright owner. Now, if you look into the bracketed portion, these algorithms do not take permission. This is the problem. At this moment, whenever we try to see how AI is interacting with copyright laws, and this is in general. If you take this into the area of patent, trademark, many other things of intellectual property, you'll find fundamentally this particular problem exists. Now we come down to point number 3. AI do not seek consent or a license. Now this is something which is brutal. Like, you have created your work, you have created your things. At least there should be a consent on your part. There is no consent whatsoever. Even when there are certain websites which portrays wonderful pictures, it categorically states that anyone who wants to take down or use this picture, whether commercial or otherwise, must take consent or permission from such and such person. This again is a blunt violation of those laws. So one defense that what I have noticed in my research is they always come up with this idea of fair use. This is fair use. The artificial intelligence computers, they take this as a fair use, and they're using it just like that. But if we look into the idea of fair use, we have to understand that it cannot be claimed as a right. If you look into the jurisprudence of fair use and how fair use, the idea developed, you'll find that it is not something which is a matter of right, but it is an affirmative defense. And this affirmative defense requires a fact, oriented system, specific inquiry. Fact-specific inquiry is something on the basis of which fair use stands, and it is on the basis of a case-by-case basis. It cannot be for all the cases that the AI generates, all the product. It cannot be, and it is an affirmative defense. It cannot be a matter of right. So those people who are aware of, rights and defense, and if you can distinguish between the two, you can very well understand why fair use doctrine will not really stand as a big defense against violation, blunt violation of the rights of the copyright owners. So this is something which all of us should be very careful about, that those who wants to defend AI systems using fair use doctrine is not in a very good position. On the contrary, if you try to defend artificial intelligence in a copyright violation case, you can say that there is no specific law preventing artificial intelligence from its use. And you can take a defense. I think that's a much stronger defense than this. Now, there are some more questions, that comes up. And those questions are, does AI systems must seek permission to use copyrighted work? Now, if taking permission, or if the idea of consent becomes a mandate, then there are two more questions that comes up. Those people who are using copyrighted work as a matter of their livelihood, their sustenance, on the basis of which their family would run, they would definitely sort for some sort of a license fee. They would definitely look forward, that they should be getting a fair compensation for the use of the work that they have done by using the principle of the sweat of the brow. So when we try to make law, or when we try to make a policy for our country, we need to look into these questions. And we need to, plan a way by which these, gaps can be bridged in the long run. Now, the question of transparency, this is a very, very important question. And the question is as to degree of transparency. I think already before I stated that the European Union policy has come up with this directive that anyone who seeks copyright must give a declaration to what extent they have used the AI, to what extent is their creativity. So this is nothing but an effort to create and develop the degree of transparency. And this degree of transparency must be there. And this will only ensure, proper credit. And if the degree of transparency is not built, then ensuring proper credit is not possible. Now, another question that I was trying to ask to myself, my research, my policymakers, my lawmakers, my audience today is, what is the status of the work? This work, this selfie, this is just as a case study. There are so many wonderfully crafted works that we can see that has been generated by AI. Can those products, those AIs, are eligible for copyright protection? This is another gap. We have to look into this and we have to find out answers. Now, the last pointer here, which is also very fundamental and important for all of you to understand, is that there can be, hybrid works. I'll just give an example. If you take an AI-generated work and you create a robot there, okay? Now, this particular robot, according to the US laws and even our modern laws, cannot be protected by copyright. But if you take away some of the parts of that robot and create something, dislocate and relocate certain things here and there, and then there is something completely different, something new, that can be definitely copyrighted. Unless and until the one that you have created, if that is a character, itself is not a copyrighted work. So if you're creating something by which you're creating a Superman or Spider-Man or Batman, even when you have done in your own way, that particular character is copyrighted already, and hence you cannot get it a copyright on that. But suppose you're creating something completely different. Then even and the basic things that you've taken in order to create that are actually AI generated work. Then you're entitled to copyright under the US laws. I hope you're understanding my point. So that is exactly what we call hybrid works. And it's important that we try to find out how, while making laws for our country in India, how we would deal with hybrid works like this. The one that I just stated is just a small example, no, not really something great. Now, we all know that majority of the laws that we all have is a balanced law. And every law in its making undergoes a lot of debate, discussion. There are different tests that the law needs to pass through. The most importantly, the cost benefit analysis, the Benthamite model comes into the flow. The Rawls philosophy of justice comes into the equation, that even when the minors, the flaws of the Benthamite principle of law also needs protection. And the legislators need to create and develop a balance. At this moment, this balance is missing. At this moment, AI is playing havoc. It is without any binds. It is moving everywhere. I would like to say, I looked into a blog write-up by one of the professors of University of California, Berkeley, asking, requesting that at least for the next 6 months, there should be no research on artificial intelligence, and especially when it comes to applicational part, it should be stopped. So if you look into this approach of not to use artificial intelligence into applicational affairs, this is not a voice that has only been raised by the professor there in the US. You'll find that it is coming up from within us, from almost all of us, from almost everybody who can understand the negative impact that the artificial intelligence can create and is creating at this moment. So I think it's important that the law should come up immediately and try to create a balance between the two. And in this case, more specifically in the artificial intelligence versus copyright issues, I think it's important that the laws should come up ahead. So what is the road ahead for us? What are the things that we need to look into at this moment? Number one, I think transparency in generative AI is important. This is number one. Number two, we have to develop policy to provide adequate acknowledgement. Now, this is one of the most important things that I stated before, and I'm trying to tell again that especially the people who are artists, they are more emotional than a real, fiduciary, based on fiduciary interests. So at least an acknowledgement is essential for them. Else it is really something which cannot be accepted. Provisions for license must be there in the laws that is in the making. And also efforts to move into the compensation jurisdiction for using copyrighted work, and especially using it if it is commercially viable. If it is used commercially, then definitely I think it's the compensational aspect must come. So this is what I thought of storing before this August gathering today. I would like to take in questions because I don't have a lot of time for today. I have some other programs lined up from 11. So just in case there are more questions, I would love to take this.
The participants, the floor is open for questions. So if you have any questions, then kindly put them into the chat box or into the Q&A box.
So with your due permission, I can see that the participants have started throwing some questions. So I'll just read it out for you, sir.
Yeah,
Uh,
please.
so the so the question is by Vishwajit Singh, that how can transparency be brought? How can transparency be brought by any AI that can make anything which we do not know of?
Yeah, this is again a very interesting question, Vishwajit, for throwing this one to me. This is a real challenge because suppose I have a website and I have a few things on sale, maybe cars or something, and the AI takes those pictures very easily from the websites and generate an amazing car which might be used for computer games coming up. So all my creativity has been used very, very effectively, but even without an acknowledgement, without any sort of information or any sort of consent. So this is exactly the point is, and I think this is more of a technical problem, which can be technically resolved than legally resolved, because if you look into this is a different ballgame. I wanted to avoid this intentionally in my talk because it's of a very small time. If you take into consideration where these big computers are in this entire globe, you'll find they're located only in 1 or 2 places across the world. Silicon Valley is one of it. Who are creating, if I have my computer, I can start playing with my computer. So in India, there can be amazing programmers, but they cannot use that level because they are not accessible to that huge amount of data, and those computers, they're not there with them. So only a set of people at this moment is creating this particular software, creating this particular program, which is based on algorithm and everything. So we need, and it's very difficult, as a matter of fact, to stop them at this moment. Okay, say for example, Meta or Facebook. Say for example, like Instagram. So these, from where all these things are coming, Google, where they are, they're exactly in that Silicon Valley portion. So if you're making a law here in India, asking that you have to implement this transparency point, the only thing that will affect these people who are making this algorithm is that to what extent the market will be affected. To what extent I'll be losing my money in India. But India has been very, open to it, unlike China. This is one of the major reasons why China and many other, Middle East countries are not very well aligned with the US talks. India can be one of that if it becomes radical and not accept these whimsical, intentional manipulation of these people who are making these algorithms. So this is a very crucial, problem, which I think will be unfolding in the time to come. We can come down to the next question. We're running out of time. We have another 10, 11 minutes left.
Right, sir. Yes,
Can
sir.
you
Sure, sir.
read this?
Sir, there's another question by Mr. Naveen Rana asking that, sir, will it be worth making a whole separate authority for the registry lawsuits to recognize the art?
Yeah, thanks, Naveen, for this amazing question. This question is very, very important. I think, how do we do that? It's all about procedural aspect. Would there be a separate registry? Would there be a separate authority? I think it should. If you ask my opinion, I think the existing Copyright Office, wherever it is not efficient enough to take artificial intelligence and these issues into consideration. So we need separate set of people who have specialization in artificial intelligence, law, and intellectual property rights to take up these matters diligently in these forums. I think this is this might be one of the best procedural formulation.
Right, sir. Right, sir. So there's one more question on by Vikram Kumar that how the proposed Digital India Act deals with the issue of conflict between AI and IPR in India.
See, this is a very very interesting question. Now, let me tell you that we are still using digital. Now, if you take into consideration in the year 2000, when the Information Technology Act came up for the very first time in India, this particular question came up, whether we use the word digital or electronic. Digits are only digits. Electronic is a much broader ambit. We still use those words. We still are in that particular phase, which is completely outdated when it comes to, like, technology market. So I'm pretty skeptical about what outcome would the Digital India Act actually would come up with. I have doubts on that. But I think, first of all, let the act come up, and then we can retrospect on it more. And maybe we can then take these questions that have just floored before the audience to test the veracity of the provisions of that particular enactment, and then come up with a critique.
Right, sir. So with your due permission, if you allow...
Perceptional wise, I don't think that the DI Act is going to make a huge difference in this scenario.
Certainly, sir. Sir, just a couple of more questions, and we know that you have some
not a problem. Yeah, not a problem.
Yes, sir. Yes, sir. So one question, another question by Vishwajit saying that in place of doing at individual level by India or any other nation, why not make rules and regulations and all other aspects to be controlled at global stage in place of individually as nation or a company or as a company? What's your thought on this?
Well, let me tell you this. This is an amazing question, and this is again coming up from Vishwajit. I really like this question because this is exactly what the big companies want. They want to rule the world directly. So far, they have been ruling the world indirectly. Initially, it was the colonial way, and after the Second World War, the neo-colonial way, and right now the electronic way. So the big data way. So this is exactly how this entire world is moving into. But we have to understand the consequence of our global legal system. This is a question which I think, would definitely be critiqued by people who are believers of democracy, who believes in the idea of federalism, who believes in the perception of rights. So I think, it's important that we need to have a global law which is fit for the purpose. And the purpose is unity in diversity.
Thanks, sir. So one last question that is by Divas Patel, asking that if AI starts to think of its own, what would happen, and is there any chance for it?
Well, as a matter of fact, thanks, Divas, for putting up that particular question. AI can think on its own. Let me tell you this. So it's not that AI cannot think. It can think, but it thinks on the line. It thinks on that specific line that is created by those set of engineers. It's run on the basis of the algorithms that has been created. I think, those students those people who listened to Anna's presentation must have got a clear idea about that work that she just highlighted about, like, the case study between the computer playing a game and the best player in the world playing the game, and how the two confronted. So I think it's very important that we know that, yes, computers can think on their own. It thinks completely different by the way we use the word thinking of a human being, but it can. because that's exactly the problem. That's exactly the stage where the problem would arise.
Right, sir. Okay, thank you so much,
Yeah,
sir,
and
for
I would
this
like to come
insightful
up with
session.
something. Sorry, Priyanka.
Yes, yes.
I have a
Mm,
quick
go ahead, sir.
question, just a quick question. Thank you so much, Professor Chakrabarty, for your presentation. It was fantastic because it made me think, it made me wonder. Unlike in patents, that you got to have novelty, copyrights, they don't have that particular benchmark of originality. You can just reinvent on the top of something that you know. And I was thinking about the picture of Mahatma Gandhi, because if you think about the picture, what is exactly protected there is the medium. It's not necessarily the content, because the content is not original. I mean, this is the face of Mahatma Gandhi that everybody knows. So that made me wonder if moral rights in India should be more, because I know that you in India we have the moral rights 1957, if I'm not mistaken, or maybe you have moral rights protection.
We have, yes, we have moral rights.
In the US, you don't have as much.
Yes.
It is very low standard, very low standard.
Right.
So perhaps if we make a system in India of copyrights that is very well founded in moral rights, we can have a system that will be so transparent for artificial intelligence. Because right now what I see is like a very good point that you made. You have so many works in the internet that they come from someone else, but nobody credited. Right? I mean, it's like, oh, that's the picture that, and sometimes you don't even know who is the creator, because obviously comes back so many layers. So perhaps moral rights wouldn't be our, copyrights is so complex. I was just wondering if we can explore that particular way of the moral rights, that we would have more countries with moral rights support. Which is unlike some countries. I think France is a very good country as an example. They have moral rights very effective. You look at the works of Rodin, for instance, that they have all the numbered on the sculptures. So I think it would be a nice example, for instance, for this particular matter in artificial intelligence and copyrights, and having this in proportion with the originality, that you don't have originality in copyrights. Pretty much, the standards are a little bit, I shouldn't say lower, but they are different from patents, for instance. I was just wondering if you can have a quick intervention, and I know we have to go. Thank you so much for your presentation.
Absolutely. It's a wonderful inclusion. I would definitely put that in the paper when we plan of writing it down and publishing it. Yes. Okay, any other question that I think I still have a couple of more minutes to talk.
Yes, sir. So there's one more question that has been asked by Arpita Saha, that if AI gets emotional intelligence and it breaches any law, can it be sued upon that, or its owner is to be blamed?
Yeah, this is again a very interesting question. Domestic laws or the law are generally, jurisdiction specific. Okay, when it comes to criminal laws or when it comes to things like that. So, say for example, I have a dog, and the dog, comes out and bites somebody outside my house. It might be because that young kid was trying to provoke it otherwise. Still, I would be liable in Indian context. Now, the question is, if that is not really a dog, but a robotic dog, and it can think emotionally, who is trying to play or trying to mock, and does the same thing, to that kid who tries to mock? What would be the consequences of this act? Would the robot be liable, or the person who's owning the robot is liable, or the person, the engineer who have developed that particular algorithm, making that particular robotic dog to think that way, is responsible, or the person, the young kid, is also contributing to that particular matter, an issue, and is contributory negligent as well. So this question that has been raised by Arpita is an amazing question, and it takes with it and brings along the various aspects and the various issues that I would have been like, more intrigued to talk and discuss for the next hour or so. But because of paucity time, actually, it's not possible for me at this moment. But definitely, this is a, but let me tell you, Arpita, at this moment, law is falling short of answering these questions. If not all, but majority of them. And that's the reason why we need to think. We are in a position not only to think about the questions, but Arpita, you need to think of the answers as well. So this is the time when we look into the various challenges, the various answers, look into the various dimensions of various answers, and then formulate a policy, which would be helpful for the world to come.
Thank you. Thank you so much, sir, for this insightful discussion that we had today. And the kind of questions that we have received today, it reflects that the kind of discussion that we had today on transparency and accountability and licensing, it was really helpful for all the participants. It must be so. Thank you so much, sir.
Thank you.
Thank you, Professor Chakrabarti. It had been a wonderful session, and I'm very sure that all the participants must have gained some insight into the topic that had been discussed over here. So thank you so much for accepting our invitation and gracing us with your presence.
Thank you, Richa. Thank you, Priyanka. Thanks, everyone else. Thanks, Anna. I think Roger is also there. Thanks, Roger. And thanks, Amity University, for hosting me and also conducting this amazing value-added course for the young kids around. Thanks, everyone, for your patient hearing and lovely questions. Bye-bye from Kolkata.
Thank you. Thank you so much, sir.
Our next speaker of the day, Ms. Reema Mendirata, she will be joining us shortly, as her scheduled time is 11:15. So I request the participants to have patience and wait till the beginning of the next session.
So participants, now let's move on to the second session of the day. And for this, I would like to extend a warm welcome to our next speaker, Ms. Reema Sani Mendirata. She's a highly accomplished professional in the field of IPR and technology transfer. As a patent agent and MHRD Innovation Ambassador, she possesses extensive expertise in patent-related matters. Currently, she serves as the head of Innovation Technology Transfer Office, where she plays a crucial role in transforming the technology transfer ecosystem in India. Previously, she has held the position of in charge and senior project manager at Innovation Technology Transfer Office at the Foundation for Innovation and Technology Transfer. Reema ma'am has also worked as a patent analyst at SS Rana and Company, which has further contributed to her vast experience in this field. Reema ma'am, we are pleased to have you here, and we eagerly look forward to your session, ma'am. The floor is all yours.
Thank you so much for your kind words. So I'm just sharing my slides, and I'm just switching off my camera because of bandwidth issue. And please confirm if my slides are visible to you or not.
Sure.
Yeah.
It's visible, ma'am.
Yeah, thank you so much. And before starting today's session, I would like to introduce you to my organization. Innovation Technology Transfer Office is one of the 7 technology transfer offices in India. It is established at FITT IIT Delhi, and it is providing its services to bionets and bioincubators, universities and institutions, innovation centers, innovators, research and science parks, and SMEs and industries. And we are helping innovators in analytics. Basically, it includes patentability assessment, novelty searches, market search, and TRL assessment. Then we are helping them in filing IP and its management. And then comes technology transfer, which includes tech assessment, creating tech briefs, scouting for the companies, and negotiation. And we are also helping them in providing legal services and marketing of their technologies as well. So as mentioned, I'm talking about basics of IPRs and its translations, because nowadays academic institutions are not only up to filing IPR, different IPR, but they are also inclined towards translation of their IP as well. There is quantum of IP which is with academic institution, but have you seen how what is the rate of translation of those IP? Means if those technologies or IP is going to the market and end users are using that or not. So my talk will be based upon this criteria. What is intellectual property rights? There is a thin line between IP and IPR. IP is basically intellect of your mind. Anything which you are creating with the intellect of your mind is called intellectual property. It can be any invention, it can be any artistic work, literary work, or any kind of industrial, any kind of design. But when you file, when you claim with the Indian Patent Office or Copyright Office and file patent application or copyright application for your work, then the rights which are given by Indian Patent Office, Trademark Registry, or Copyright Office for your intellectual property, it becomes intellectual property rights, because these rights are given by Indian government. So these rights are legally enforceable as well. So in short, IPR is basically the safety belt for your ideas. So what is intellectual property rights? Like there are different types of IPR, patents. You file patent application for the functional aspect of your technology. And if you think you have a unique name, or it can be unique name, combination of word or logos, then you can file trademark application for the same. And if I come to the look and feel of your technology, suppose you are working on a product and you are giving, there is a aesthetic feature in look and feel of the technology, then you can file industrial design application as well. And copyright is basically filed for any literary item, any artistic work, musical item, cinematography. So you file copyright application. Trade secret, there is no mandate to file any application to secure trade secret. It is confidential, and the owner has responsibility to keep it secret. And if he or she has to share it with the employees, then the NDA or the strict clauses on confidentiality can be added in their employee certificate. Talking about the AI, artificial intelligence, in our day-to-day life, we are coming across with AIs, and Chat GPT is one of the examples of those AI-based applications. And there is lots of, it is a debatable matter in India as well. So I will touch upon this AI application and how we can secure them. What are the rights can we can obtain for AI based application? Nature of intellectual property. Basically, these are the creation of our mind. And unlike other properties, these are intangible in nature because you can't touch them. And the IPR is basically exclusive rights. If you have created something and you have filed patent application for the same with Indian Patent Office, in return of that, they will give you exclusive rights over your work. And indirectly, you are creating monopoly in the market as well. And intellectual property rights, these are territorial in nature. Suppose if you have filed patent application in India, then you can only enjoy these rights or the patentee rights in India only. But if anyone is, infringing your rights in US, then you can't take any legal action against that person in US because you have not filed any application in US. And each type of IPR is time bound in nature. For example, patents are granted for 20 years from the first filing. Trademarks are registered for firstly 10 years, but you can file renewal for the same for multiple times. And that's why sometimes the immortal word is used for the trademark registrations. And because all the rights are given by the government, so these are legally enforceable as well. You can take legal action against the infringer. Benefits of IP to university and educational institution. Basically, in COVID era, you all must have noticed that most of the innovative solution for COVID have come from the academic institution. So indirectly, you are giving creative or innovative solution to our society. And if your IP has worth, it has commercial potential, then you may attract the better collaboration as well. Why? See, if you are not able to work on your technology, you can always have collaboration with any industry who can take your technology and work further upon that. And then they may help you in taking your technology to the market. Tech transfer plays a very critical role in this. Brand value. For any academic institution, the IP act as brand value for them as well. For NIRF ranking, they consider how many IP you have filed, granted, and how many technology transfer you have done. And if there is, you are creating or fostering innovation ecosystem at your organization. And the next is if faculty and researchers they think they want to take this technology further, they can form their own startup. And the term which is used is spin-off. Spin-off is basically the startup which is created by that faculty or researcher from the academic institution. To run a startup, you will need other people to assist you. So you will hire people as well. Indirectly, you are creating employment for them as well. So drawbacks of not protecting your IP. If you have not filed any patent application for your work, then anyone can copy your idea. And because you don't have any right over it, you can't take legal action against that person. And that person may use your idea, and because they have already existing resources and facilities, they may launch the product or services in the market before that. So indirectly you are creating competition for yourself in the market. Patents. So patents are basically the exclusive rights which are given by Indian Patent Office in return of disclosure of your invention with them. So patents are granted for product as well as for the process. The tenure for patent is 20 years from first filing, and after that you can't renew it. So this is the initiative of our government to avoid the evergreening of patents. Otherwise, in case of drugs, the life-saving drugs, the companies may have monopoly over those drugs, and no one can make generic drugs, and it will be very expensive for a middle class people. So because as I mentioned in my earlier slides that these IPRs are territorial in nature. Suppose if you have filed patent application in India, then you can only enjoy the patentee rights in India. If anyone is using making use of your idea in US, then you can't take any action against that person because you have not filed any patent application in US. Because in case of patents, you are stopping others from using your idea. So these rights are also called negative rights in nature. And like other property, like other tangible property, patents can also be sold, licensed, mortgaged, inherited, and transferred. Rights of a patentee, they have right because as I mentioned, this is your monopoly as well in the market. You have right to manufacture or use, you have right to sell the patented invention, and you can prevent others from importing that patented invention. Reason to file a patent application. Suppose in your lab, you know you are filing patent and you have invented something which is very unique and has a commercial potential, inventive stuff, then if you will file patent application and it will get granted, then it will be like incentive to you. So because now you can add it in your profile as well, and it will motivate others as well to file more IP and to do really good work. And it encourage research and development. It fostered that kind of culture at your institution. And most important thing is that it will bring technologies to the market. If your work is worth and you got grant over that, it is like your dedication towards your work, and it also attract the investors as well. They because it is very tough to have the granted patent, because patent is granted to those innovation which are novel, have inventive stuff, commercial potential, and they are patentable subject matter as per Indian Patent Office. So these things attract investors as well, and industry may also hold an interest in your technology to take it further. And it also promote commercial exploitation of your technology. So these are the few criterias which are really useful for any innovator to analyze if his or her innovation is qualified for filing patent application or not. The first one is it should be novel. Novelty means, as per Indian Patent Act, it should not be in the public domain in any manner. It is said that only the one paper worldwide can kill the novelty of your innovation. And the second patentability criteria is non-obviousness and inventive step. So your innovation should have technical edge from already existing technology. And if it is cost effective, then also it is very beneficial. And the third thing is it should have the industrial application and the commercial potential. And the fourth and most important criteria is your innovation should not lie under Section 3 and Section 4 of Indian Patent Act. So as I mentioned about something, I'll touch upon AI, artificial intelligence. So artificial intelligence, it is still a debatable matter in India because of the inventorship and ownership. In India, you can't file any patent application in the name of any AI. You can't file that. This is the inventorship and ownership as per the Indian Patent Act, Section 2 and Section 6. It deals with the inventors who can file, or the applicant who can file patent application. So you can't file patent application in the name of any AI, any robot. So this is very debatable matter. So this is the first DABUS. Is basically, it is a food container based on fractal geometry, and it is invented by device for autonomous bootstrapping of unified sentience, DABUS, and it was invented by Dr. Stephen Thaler. And when the application was filed in the name of DABUS, it was rejected by USPTO, UK, EPO, JPO, and China. Only the South Africa, they have issued a patent to this AI based tool, because there was in their patent act, the definition of inventor was not at all described in a proper manner. But in India, it is not, it cannot be considered. If I talk about, in fact, if I talk about any algorithm or any software per se, they themselves are not patentable subject matter in India, or any mathematical calculation. So in India, you can't file patent application if your work is pertaining to any AI and any software or mathematical calculation. And the second thing is inventorship or ownership in the name of AI tool. Any AI based application, you can't file those application in the name of any AI based application. Types of patent application filing. So you can file patent application in India where you are not claiming any priority. So you can file patent application, you can file provisional patent application, or you can directly file complete patent application. So there is, suppose if you think you still have to work upon your technology, and in parallel to that, you want to reserve the priority of your innovation, then what can you do? You can file provisional patent application, and within 12 months of time, you can file complete specification when you think your work is complete. Or the second scenario is, if you think your work is completed and you need not to further work upon that, then directly you can file complete specification. Now, convention application and PCT application. Suppose if you want to file patent application in abroad, more than 2 countries, then there are 2 routes by which you can file. One is Paris Convention, second is PCT route. But PCT has edge over Paris Convention in respect of time, because PCT is basically a platform through which you can file patent application in various countries who are member to PCT. After filing PCT, you will get 30 to 31 months based upon the country's norm. So you can file a national phase patent application. So in that case, you have benefit of having 30 to 31 months timeline, during which you can decide the market potential of your technology in that particular country. So because filing patent application in abroad is very expensive. So before filing that, you should do your homework. You should calculate the market. You should conduct the market potential of your technology in those country, and what will be the future of that country. that technology. So after that, you can file the national fees application. So as I mentioned, I will touch upon these things, translation of IP as well. So this is the one example in which, that innovators from Florida University and how they earned money out of their innovation. So when you are in this field, you should open your eyes and ears, and you should observe what are the unmet needs and how you should work upon those needs. So way back in 1970, the innovators from Florida University, they realized that dehydration faced by the football player, so they invented this beverage and given the name as Gatorade. So when they were approached by a company, and the company decided to give the Florida University the upfront payment and the bonus or the royalty amount. If we calculate the royalty amount which Florida University is receiving, it is in millions. So this is the best example. If you think you are not able to work upon your technology, and you at that time, and you have no resources to take it to the market, so you can collaborate with the industry, you can give your technology to that industry, and they may take those technology to the market, and in return of that you can earn revenue out of it, and that revenue can be used for further R&D process of your university. And this is the second example of innovator who didn't get rich because he didn't file any IP for his innovation. So Daisuke Inoue, he was the inventor of karaoke machine. Karaoke machine is basically the amputee orchestra. So during COVID, I think all the people who have interest in music have used this karaoke machine. So he was a Japanese businessman who used to earn money by playing drums in a backing band. And one time he could not make a gig, so he put the backing music on tape instead. And later he made 11 karaoke machines. But he he had given them on lease, but he didn't file patent application for his invention and barely made yet. If he would have filed patent application and transferred the technology to any big company, then he would have earned a lot of revenue out of his technology. So sometimes because of our ignorance, we lose the chance of earning revenue out of it. Not only revenue, if I think about the other perspective of commercialization is to help the society by giving innovative solution to them. So it happened many times. So better way is to take help from any professional who can have formulate IP or TT, strategy for your work, and then maybe you can earn revenue out of it, or if you want to pursue with that and you have resources, then you yourself can take the technology to the market. So trademark is basically one's identity in the market, and basically it is the brand value of any company in the market. Suppose if you are if you are thinking of launching your business in the market, the first thing you should do is to protect the name of the company or the trademark of the company, because it will act as a brand value for your company in future. When McDonald's or Starbucks, they decided to launch their business in India, the first thing they did, they filed trademark application in India first. They first protected it and then launched their business in India. Because it is really good to protect it first. And after protecting it, if anyone who is infringing their trademark, they are taking action against those persons, because it is basically they are diluting their trademark, and maybe they are they are diluting the brand value of their trademark by giving substandard products under the same trademark. So the trademark, they are registered for 10 years, but after that you can renew it multiple times. Again, if I talk about the literal definition of trademark, they are any sign that individualize the goods of a given enterprise and distinguishing them from the goods of its competitors. Because if you want to buy any Apple phone, then you can distinguish it from any, you know, Android phone, and you know the quality of Apple phones which they are promising to the customer. But can be trademark, any word mark, any logo, or the combination of the same, any colored mark, and sound and smell marks can be trademark. But these are the non-conventional trademark. So smell marks are you can't file in India. Now, can we file trademark for any AI-based application in India? Yes, you can file. If you have any unique name or any unique logo, and which is as per trademark act, which can be registered, then you can file that. Copyright is basically the bundle of exclusive rights which are given to the creator of the original work. And the important thing about copyright is that it is not mandatory to file copyright application for your work, because as and when you have created the work, so the copyright rights are automatically, they generate over your work. The copyright, basically it protects ideas which are expressed in a tangible form. Suppose if any poem which is in your mind, you can't file copyright application for the same. If you want to file, you have to write down on the paper, and then you can go for the copyright protection. The next thing is that if you are producing any copyrightable work during your employment, then the work which is made in course of employment, the main owner of that copyright will be your employer. Why? Because in your employment agreement, it is mentioned that the work which will be produced by you during your tenure, the main owner of that work will be the employer, and you will be regarded as the author of that copyright. So this is the important thing about copyright. Artistic or sound recording work is copyright subject matter under Copyright Act 1957. And if I talk about any software per se, artificial intelligence, algorithm, so you can file copyright application in India for protection of those work. But if I,
Uh, if I may interrupt, ma'am, your presentation is not visible, ma'am.
okay, sorry. Is it visible now?
Yes, ma'am. Yes, ma'am. It is visible. Please, ma'am.
Okay, sorry, I was not aware. So industrial design is one of the IPRs in which the application is filed for the look and feel or the aesthetic feature of that article. So it protects designs that are applied to the articles. Means if you have drawn something on drawing book, then you can't file industrial design application for that work until or unless you have implemented that design on any article. So it is one of the categories of IPR where the design system it focuses on the aesthetic feature of an article. So it can be filed for shape, configuration, surface pattern, color or line or combination for the same. And the protection is for 10 years and further you can file renewal as well. So basically nowadays the innovators are really smart. What they do whenever they are working on any product, they take the help from the product designer who may help them in creating the look and feel of that product so that they can file industrial design application for the same. And if you have multiple IP for your work, for your technology, it may attract investors as well. Because by filing multiple application like industrial design, patent application, trademark application, copyright application, this way you are creating IP portfolio for your technology. Significance of patent searches. So basically by patentability assessment or novelty searches, you are avoiding reinventing of wheel because from these searches you will come to know about the technologies which are already in the public domain. And as I mentioned, for filing patent application, you have to qualify for few criterias, and one of them is novelty. And if it is already in the public domain, then IPO will raise objection over it. And also because filing patent application is very expensive, and also it takes so much time. So to avoid all this, you should always go for patentability assessment and novelty searches. Strategies to protect innovations. First of all, if you are working on any project, then scout for IP at an early stage as well. And how can you do? On your own, you can search for the novelty of your innovation and from the Google patents as well. And then you can, if you think you can take help from the professional and file, suppose if you have to work on the innovation, then you can file provisional patent application for the same. And the second step is you have to determine what are the IPs which need to be formally registered, like patent application, trademark, industrial design, and who can arise automatically, like copyright application. And most of the time, there is a fund crunch, and on the basis of that, you have to, plan how you can protect and which IP you can create, you can file, like patent application and industrial design application. It depends upon the novelty, and as and when you have created, you should go and file the same. But for the copyright and for the trademark, you can still, wait for the same, and whenever you have funds, then you can file the same. Because in case of trademark, you can mention that you are using this trademark since at this and this, and you can produce evidence as well, like bills or anything where you are using your trademark. Formulation of IP strategy. First is where to file the patent application. Suppose the origin of your innovation is in India, then you should first file the patent application in India, then you should go to the other countries. And In other countries, before filing, you should conduct market potential of those technology in other countries. And on the basis of this market potential, you should file patent application or associated IP of the technology in other countries. So this is the way. Suppose you are ready with ITF, you should disclose it with the, your IP cell, and then they will evaluate your ITF and let you know if it is patentable subject matter or not, or if there is any scope of improvement or not. And on their decision, you will either go for filing patent application, or still you will tweak in your research and make it more innovative or patentable. And after filing patent application, you can check for other associated IP in your work as well. And if you think your innovation has, your technology has worth in other countries, then you can file PCT or convention application as well. This way, you are creating IP portfolio for your technology, and this may attract other investors as well. Now come to the translation of IP. Translation is basically the transfer of research outcome from any person or from any organization. Organization can be any academic institution, research institution, or startup, to any another person or organization. It can be any small company, big company, startups as well, with aim to transform scientific outcomes into the new products or services. Suppose if you think you are not able to work on your technology, and to avoid all this thing, and you can transfer your technology to the industry. There is a benefit of transferring the technology to the industry, big company, because they have their existing, I would say, connection, they have resources and the supply chain as well. So you can leverage all this thing, and this will help you in commercialization of your product as well. So what gets transferred? Any technical information, which you have the know-how, which is the performance skill set of the technology, any IP associated with your technology. It can be patent application, trademark, industrial design, or copyright, or any technical material or equipment. They can be transferred. So how it gets transferred? So there are different ways by which you can transfer your technology to the industry. So first is licensing, then assignment, and third is co-development. Licensing is basically if you think you are not able to leverage or to commercialize your technology, then you can give license to the big company for a limited time period and the restricted jurisdiction. So it can be exclusive licensing or non-exclusive. In case of exclusive, you are giving license to only one company, whereas in non-exclusive, you are giving license to two or more companies. In licensing, there is a in licensing. Suppose I'm startup, I want to increase the portfolio of my technology, and with the, so to avoid the reinventing, I will go with the transferring the technology. So I will take technology from other company, organization, academic institution, and take it to the forward. Because I'm taking in it, it is mentioned as in licensing. Whereas if I'm transferring my technology to the company, it means out licensing of the technology. So in licensing, you are giving your rights for a limited time period, whereas in assignment, you are giving away your IP rights to the company forever. It is just like if you are giving your home on rent, it is just like licensing, and you are getting monthly rent out of it. Whereas in case of assignment, you are selling off your house. So you are entirely giving away your IP rights to the company. So the third term is co-development. In this case, we can collaborate with any industry and mutually work on the technology and doing our efforts to take it to the market. So it comes under co-development. Facilitators. So technology transfer offices, they act as facilitator. IP cells or tech transfer professional, they help you in filing IP, its management and technology transfer. They help you in formulating IP and tech transfer strategy as well, which is very important for any innovator to have this. Sometimes because of the poor IP and TT strategy, they are not able to get enough funding or to commercialize the technology. So better to take help from the professional, and it helps in forging linkages as well, which are very important for fostering innovation ecosystem, and also it helps you in commercialization. Tools for tech transfer. So the most important tool is the policy framework. IP and TT policy, it is very beneficial for any academic institution if it is, because the policy is basically the set of guidelines which are helping innovators, if they are ready with their technology, where they have to contact, what is the template of idea, whom he has to contact, and who will evaluate the technology, who will file the patent application or other associated IP for innovator. So everything is well mentioned in that IP and TT policy. And if you are transferring the technology, because in most of the academic institution, the ownership of IP is with academic institution, because they are funding or providing resources to the innovators. Then what will be the revenue sharing model? All the clauses are mentioned in the IP and TT policy itself, and it helps in tech transfer as well. The second is license agreement, assignment, non-disclosure agreement, material transfer agreement. It acts as a backbone for any licensing or tech transfer deal. Marketing content, basically, if you are ready with your technology, you want to transfer that, then you have to spread the word about your technology, only the non-confidential words. So this is captured in a manner, in a fanciful manner. Tech brief is a one pager on the technology wherein not confidential information about the technology is mentioned. Like what is the innovation all about? What is the USP, benefits or application? What is the status of that patent or IP which is filed for that technology? And the brochure is the detailed version. An advertisement you can give in any newspaper wherever you want. So this is the marketing content which should be non-confidential. In case if there is no IP or TT policy in any organization, then it may lead to the IP ownership issue and issue regarding revenue sharing. As I mentioned, these agreements are the backbone of any technology. So marketing is basically, if you want to spread the word about the technology, how will you do that? First of all, you should be ready with the content of the technology. What is the technology all about? What are the benefit or application of the technology, and status of IP? So all these things should be mentioned. Only the non-confidential information should be disclosed. And the most important thing is marketing strategy. Based upon the technology, you opt for the marketing strategy. And how will it work? It will work like, if you have to do direct marketing or indirect marketing, because it is very tough to get the detailed information about the R&D head in any company. So you can approach through LinkedIn, or you can send one-on-one emails, you can have in-person meetings with the company head. So this is the way you, based upon the technology, you offer different marketing strategies for the same. Next is do's and don'ts. Do's. Basically, when you are transferring your technology, you should have the clarity of type of transfer. The first is, are you giving the license on exclusive basis or non-exclusive basis? What will be the tenure of licensing? And what will be the jurisdiction of using that technology? So all you should have all the clarity on this thing, and it should be captured in the license agreement as well. And all the agreement should be in order. For example, if you are having meeting with the company, then first you should sign non-disclosure agreement with them, because in most of the cases, what does company do? They will have meeting with you without signing NDA, and after a few months they can use your technology for your work, and you have no any evidence, so you can't take any action against them. So better to sign NDA with them and then go ahead with the discussion. Don't. Sometimes innovators of the license, they don't mention confidentiality terms in the license agreement. So this is lost to the licensor. Suppose if you are giving away your technology on non-exclusive basis. So if the first party to whom you have given this license and they are not maintaining the confidentiality of the technology, then how will you give that license to any other company? And the second thing is that you should have clarity on the upfront payment, milestone payment, or the royalty amount. And everything should be captured in the license agreement. Even the mode of payment should be mentioned in the license agreement itself. Myths which are associated with any tech transfer. The first is any technology can be transferred. No, this is not true. Only the technologies which are unique, have inventive step, and most important, they have commercial potential and they are meeting the unmet need of the industry can be transferred. The second is IP protection is must. No, it is not must. Even we can transfer the know-how of the technology as well. And the third is, you need a granted IP to transfer. No, even the IP which you just have filed, you can go for transfer of those IPs as well. The fourth is very important. Anyone can transfer a technology. No, only the person or the organization who holds the IP ownership rights has the right to transfer the technology. In case of university, the applicant is usually the university or the academic institution. So they have first right to transfer the technology. But if the innovators who are working on the technology by creating their spin-off, by forming or startups, what they can do, they can transfer the technology from academia to their startup, and then they can work upon that. So this is all about basic of IPR and its translation. Hope I have cleared your few doubts. If you still have any doubt, you can please ask me.
Thank you so much, ma'am. I request all the participants, you can post your questions on the QA chat.
Dr. Rita, I just want to confirm if all the students have participated for this course or only the faculty members are there.
No, no, ma'am. It is a mixed group. Mostly there are students who are the part of the workshop, but it was also open for the professionals and the faculty if they wanted to.
Okay, okay, great.
But the majority is of students.
Okay.
Ma'am, is it fine with you that if you could share a bit on technology transfer?
Yes, yes. So technology transfer is basically if it comes to the commercialization of any technology. So there are two ways by which you can commercialize your technology, product or process, anything it can be. So first is spin-off. I'm talking about the academic institution. Spin-off is basically the nomenclature for the startups who are formed from any professor or the any faculty or researcher from that academic institution. Basically, what is the benefit of forming that startup? Because there are so many funding schemes and tax rebates which they can opt for after creating the startups. Because many government or non-government organizations, they give funding to the innovator for the different stages of the technology. They provide seed funding to the prototype building and for these clinical trials and everything. So this is the benefit of creating startups. And the second thing is technology transfer. If you think you can't take it further due to time constraint or the funding constraint, it can be anything. In that case, you can transfer your technology to any industry. And after transferring the technology, you can have monetary benefit, like you can have upfront payment or milestone based payment and royalty as well. But for the academic institution, it should be taken in consideration that whenever you are transferring your technology, you should not give your R&D rights to the company. If you, and you should explicitly mention in the license agreement that we will reserve the R&D rights with the university itself. Because if you will give it on exclusive basis, or maybe the company will think, okay, now the academic institution can't work on this technology further or its derivatives. So this is all about the tech transfer. There are, it seems very simple process, but frankly speaking, it is not so simple. Multiple stakeholders are involved in it, and multiple meetings and multiple negotiations. So it is a very long or complex process. But yes, if you think you can't have it on your own, you can't commercialize it, then you can approach the big companies. And because big companies have their own resources, they have in fact supply chain as well, by which you can leverage all those facilities or resources and you can commercialize it. Because in case of academic institution, they basically what they are up to, they basically want to help the society as well. Revenue is secondary, because and the most important thing is you are investing a lot on the technology development, right? Your time, funding, other resources, and it is really motivating factor for the university or the innovators that their technology should come in the market, and they may get feedback from the end user as well. So this is the complete cycle. If you are only filing patent application or other associated IP with your technology for the sake of number, then there is no benefit until or unless you are commercializing those assets.
Right, ma'am. Thank you so much, ma'am. Ma'am, there's one more question that I wanted to ask because I am from academic institute and you two are from a research institute, which is also an academic institute. So, supposedly, an academic institute gets into a partnership with any private entity, any private organization, and they filed for a patent, right? Now, in that case, like we have been seeing that government of India is giving a lot of incentives to educational institute when it comes to patent filing. So, if there is a private entity, associated with an educational institute, in such a case, would the educational institute get the benefit of the subsidy, or will it have to pay the full amount for patent filing?
So this is like we have to confirm with the IPO, but this subsidy is only for the educational institution, not
Okay,
for the private.
not for the private institutes. Okay.
1600 rupees if you are filing as an education institution, then you have to give evidence as well. The publication in any gadget that this is university or educational institution. This is the reason behind that. This subsidy is only for the educational institution, or if you are startup, then you have to submit that declaration form as well that you are a startup. Otherwise, for if you are filing in the name of any private entity, then you won't be able to, avail that opportunity.
Right. Ma'am, there's one more question. Like, you would be saying that all the questions are coming from me because it is one area that I'm very interested in when the technology transfer. Ma'am, if you could give any example of technology transfer that might have happened from IIT, that you would have supervised, something that would have contributed to the society. So if you could just throw some light on it.
So in November 2022, we transferred know-how or industrial design of a hydrogen fuel bike. Earlier, the discussion was on transfer of industrial design. So one company, this is Bangalore-based company, no, Hyderabad-based company, Community Energy, we transfer it to that company, but it was we were transferring industrial design, but the professor who was innovator of that industrial design, he said, I want to transfer the know-how of the technology as well. Why? Because he wanted to contribute in the country within the same amount. He had transferred know-how and industrial design of the technology. Why? Because this is hydrogen fuel bike, which is future of India. And not only transferring the rights, he is also providing handhold services to the company for development of that hydrogen fuel bike. Wherever company has to go for funding or pitching, so that professor is always with them. He is helping the company in development of the prototype, and then mostly for the commercialization as well, he will help them.
Thank you, ma'am. I won't be asking you any further questions because my questions will know no end here. Uh, if the students they have any question to ask, if
Uh,
there's any discussion they want to have with the speaker, then the floor is theirs. Yes, Priyanka, ma'am.
Okay, there is
uh,
one question from Vishwajit Singh. Transfer
yes,
of
ma'am.
AI also comes under tech. Can it also be transfer any law? See, the software, if I talk about any software or AI, we already have transferred the software of the technology. But the thing is that in case of any AI based application, is that if you are transferring it, then it comes, how will you measure the infringement, or you won't be able to prove the uniqueness of that thing, because how it is unique, because most of the open source softwares are there, and up to which extent the innovator has modified it. But yes, if you think innovator claims that it is innovative and he has not taken it from any open source, then we can help them in transfer of it. And not only this, if we can also transfer the trademark as well and the copyright for the same, because in case of software in India, we can only file this copyright application. So yes, we can transfer that because ITTO has already transferred the software of a technology. And the RTTP designation, RTTP is basically Registered Technology Transfer Professional. It is a globally recognized designation, and ATTP, they recognized the, professional with this designation, but you have to go through a rigorous training sessions, and you have to do some cases, you have to close the deals on tech transfer or any collaborations. And then you have to file the application with ATTP, and they will evaluate that application, and then they, as per the decision of the committee over there, they will either they will give you designation of RTTP or candidate RTTP based on your experience as well.
Ma'am, I have a question. You had discussed that there are certain material transfer agreements. So,
Yes.
ma'am, can you please elaborate and give, if you
Okay.
have any examples with respect to material transfer agreements?
See, material transfer is just like if I'm working on my work, right? It is a technology, and I need some kind of material which in another institution someone is working on that, and they have already created that material. So in spite of reinvented the wheel, I can ask for transfer of that material, and I can do the tech transfer for the material as well. So it can be any biological material as well. It can be any equipment, anything.
All right, ma'am.
Yeah.
Uh, Participants, um, you're free to ask any questions from ma'am.
Ma'am, there are
There
two
is a question.
questions.
The proprietary right issue for honor of technology in technology transfer. So, so IP and TT policy, it plays a crucial role in this. That's why I mentioned every academic institution should have IP and TT policy in place, because the organization or the person who holds the IP right, means who is the applicant in that IP, has power, has rights to transfer the technology. Any person, any innovator or the inventor can't transfer that technology. Only the person or the organization who is applicant in the patent application or any other IP can transfer that technology.
Ma'am, there's someone who's interested in knowing what is RTTP designation.
Yeah, I have already mentioned that. It is Registered Technology Transfer Professional. It is globally recognized credential, which are given by ATTP. And for this, you have to go through a, rigorous training sessions. You have to earn credit points. You have to close some TT deals or collaboration projects in which you have to show your contribution and how it was important in closing that deals or collaboration. And then you have to file the application. Then the committee at ATTP will give their decision if you will be recognized as RTTP.
Thank you, ma'am. I hope, Priyanka, ma'am, there are no other questions to take up.
No, ma'am. I think all the questions have been taken up by ma'am. Yes.
So, ma'am, I would like to take this opportunity to thank you for your contribution to the session, for being part of the workshop. Thank you so much for gracing us. And over to you, Priyanka ma'am.
Yes, ma'am. Thank you, Tina, ma'am. It was a very enriching session on IP and technology transfer. So, and we are so very grateful, ma'am, to have this opportunity to learn from you.
Thank you so much. If anyone has any doubt, you can please ask me on my email. I will be happy to answer all those questions.
Sure, ma'am. That would be very helpful for all the participants.
Thank you. Thank you so much.
Thank you
Thank
so
you.
much, ma'am.
Thank
Yeah,
you.
I'm now taking leave from this session. Bye.
So the participants, we will be closing the session now. Over to you, ma'am. You can
Yes,
share
ma'am.
the session
So
screen first.
we will be coming back at 1:15, right, ma'am? So we will be joining back at 1:15. So all the participants, there's a 1 hour break, and we'll rejoin at 1:15. All our participants to rejoin.
Actually, generally present. In the morning, actually, I was there for some time. I was listening to the deliberations of Shambhu sir and Maniratnam, and there were about 180, 190 participants.
Yes, sir. Yes, sir. That is right. Right now we have around 120 attendees who have joined back. So we are just taking few more minutes for everyone to
Oh,
join
that's
back.
fine. That's fine. I have a small presentation. Actually, I was asking Richa ma'am in the morning that whether a PowerPoint slide is necessary. I have all of the presenters deliberated by using the PowerPoint slides.
So most of them, yes, they have. But sir, that is fine. We can have a
I have
discussion.
a very curt PowerPoint slide presentation. Most of it would be extempore actually.
No problem, sir.
Okay.
Good afternoon, sir.
Good afternoon, ma'am.
Richa ma'am, we are just waiting for 1 or 2 minutes for all the attendees to join back.
Yes,
Yes, ma'am.
yes.
So, good afternoon, everyone, and welcome back. So as we move forward, I would firstly want to encourage all the participants to actively participate in the Q&A session after each presentation. And you're free to ask if you have any questions or you want to share any thoughts with our experts or you want to interact. So please feel free to do so. So now let's dive straight to our next session. That is the third session of the day. And for this, we have our expert speaker, Dr. Rajat Banerjee with us. He is currently working as assistant professor at Amity Law School, Amity University, Noida. And he has more than 16 years of work experience, which includes in teaching and in research. So far as his academic accomplishments are concerned, he qualified BA honors in political science from Calcutta University, MA in political science from Jawaharlal Nehru Universities, that is JNU, MPhil in political science with specialization in international relations from JNU, LLB from the Osmania University, and LLM with specialization in international and comparative law from the West Bengal National University of Juridical Sciences. He was conferred with PhD degree by West Bengal National University of Juridical Sciences. He has a few research publications, including publications in Scopus Indexed and UGC Care listed journals. He has also qualified UGC NET in political science, law, criminology, and human rights and duties. His area of research interest include comparative in constitutional law, public law, and policy, IPR, human rights, law, and technology. Sir, we are really grateful for you to join us for this session, and the floor is all yours, sir.
Welcome, Rajat sir.
Welcome, Richa ma'am, and welcome, ma'am, for Priyanka ma'am for such vivid sort of. You've actually literally spoken out my profile. Uh, but a very warm welcome to all the listeners in this webinar, in this ongoing value-added course on IPR. In fact, it's a wonderful initiative to have stumbled on one of the most interesting and violent topics in today's legal and political discourses and social discourses, of course. And I've not been able to attend all the lectures. I've been hearing a few, and of course the initiative is wonderful, and I will glide through this topic and also focus on the relevance of artificial intelligence, the relevance, rather irrelevance, of artificial intelligence, and and its intersection points with the reference to the copyright laws, especially. So artificial intelligence has a lot of bearing on other IP laws. I mean to say on patent uh, geographical indication and others IP areas, law areas. But my focus today would be on artificial intelligence and the general issues circumscribing artificial intelligence and copyright. Now, I believe in the very first today being possibly the last day, tomorrow is a valedictory, if I'm not incorrect, Richa ma'am.
Yes, sir. Tomorrow it is.
So today in the morning session, I was hearing Professor Dr. Shambhu Prasad. He had wonderfully tried to sort of, he used a tapering down approach in order to understand where we are with reference to artificial intelligence and copyright, and to what extent artificial intelligence may be used, and whether the misuse or the unfettered use of artificial intelligence with reference to copyright law is at all permissible, in the ensuing legal discourses. Now, having said that, having made passing references to what to the discussions that had already happened with the reference to AI and copyright, let me take a sort of not a statutory, a formal view of AI, because almost all the speakers have defined AI, artificial intelligence, and algorithms, and how it operates and the methods. I will be making passing references to the methods. But however, my focus in today's deliberation, I'm not sure how many participants are listening, but even then, even if I am speaking to most to a very few, I would refrain from going too much into the what shall I say, the data concerning how the problems have happened, where the problems have happened. So I'll go into the theoretical part a bit, and then try to understand whether actually artificial intelligence is helping us out, or whether we are creating a problem for ourselves. Having said that, if Richa madam and Priyanka Gupta madam would allow me to open the slide, I would like to do that.
Yes, sir. The option is available for you.
Okay. So kindly let me know if it is open.
Yes, sir. So you may share your screen, sir.
Is it visible now?
Yes, sir. The screen is visible.
Okay. So to begin with, are the copyright
If you could,
issues?
sorry to interrupt, but if you could put it on the presentation mode, then it'll be clearly visible.
Presentation mode.
Yes.
I'll just try.
So you can start the
Video
slideshow.
Slideshow, sir.
slideshow. 1 second, please. Slideshow. Okay. Then it will be from beginning or from current
Yes, sir.
slide?
So from the beginning, you can start from the beginning.
From beginning.
Yes, sir.
Okay. Is it showing?
Yes,
sir.
sir. It's visible, sir.
So kind of you, Priyanka ma'am and Richa ma'am. So the topic is the AI issues, vis-a-vis copyright. Now, the first point that I would like to discuss about AI, I do not know whether other speakers have also spoken on the same topic or on a similar topic, but how is sort of, let us look at AI from a very pristine lens, from the pristine lens of who shall determine our lives. So shall it be determined by ourselves? Shall it be determined by the society or by the existing environment? Shall it be defined by any defining technology or any emerging technology? So this, when it all started in the late 50s, early 60s, followed by that in the early 70s, the main focus was that we would move away from our primordial instincts to adopt ourselves to certain things which are somehow new to us. And so we started determining our lives through technology, through technology, and the advent of new technology, including computer technology, started determining our lives. And this is wherein the theory of technological determinism becomes quintessentially important. So, our cultural values, the ways that we think, what shall I say? The Morse, the folklore, everything, each and everything started being defined by later on it was replaced, of course, by the neural networks and by the advanced intelligence systems. But technology, so we started believing in the fact that we must be driven by technology. We possibly fail to think that we must define technology and determine technology till a point we can embrace, and till a point we must not embrace. And then, so we all started about 50 years, 40 years down the line back. If you reminisce, if you look through the lens of history, we started with something called technological determinism. So so we all thought that it is a science and technology that must guide us, and that must guide our lives, that must determine the way we think. And so was that, we created various forms of technologies. And we also, later on, we also developed the principle of technological neutrality, wherein, it is a concept, rather a theory or a doctrine, which says that, someone must not be biased about a particular technology, meaning further that we must move away to embrace a particular type of technology, an alternative technology, maybe. And if it is, if a matter is non-technology driven and if a matter is technology driven, we must create parallels between the two. So resultantly, what happened was that we created parallels. So first we determined that our lives and living must be decided by the technology itself, and then by the logic gates themselves, and by C++ or COBOL or Java, or for that matter any other programming language and the like. And then we adopted the principle of technological neutrality. And last but not least, the present, maybe the last decade or so, we have moved away. In fact, in creating parallels, we created the parallel, but we generally we have moved away from the regular parallel to the technological parallel. And then we have adopted something called the principle of technological singularity, which says that technology and technology only must determine our lives. So for example, when we take classes, conduct classes, or when we sort of see ourselves in social life situations or in real life situations, we almost about 70% of us are hooked to some technology other. I mean to say, whether it may be an iPad technology or an iPhone technology or any other technology or a laptop or any other technology, somehow or the other, our lives are so much determined by technology that we cannot, and technological growth is so uncontrollable and irreversible that we have come to think that it is technology and technology only which can overdo human intelligence. Now, that is one of the inflection points in this growing debate on whether or not we shall adopt artificial intelligence. That the question circumscribes around that who are our creators. Did the technology, my question to all the audience, at least out of the 150, I can see 146 participants, at least about 46, if not 46, about 6 participants are listening. If 6 participants are listening, my only pristine question to them is have we created the system or the system created us? So who created computers, whether it was Charles Babbage or whether it was the ARPANET, connecting different workstations and different computers across networks, one of the erstwhile networks, but it was nothing but a human creation. It was a creation of human intellect. We somehow thought that we must move away from self-determinism to technological determinism, to high-flavor technological determinism, and we started believing that technology has the potential to create superhumans. For example, take the case of CRISPR-Cas9. Myself and one of another scholar, we were working on the CRISPR-Cas9 technology. That is also a technology. May not be a technology. It is also AI assisted technology. May not be applicable, in this forum. But a talk of CRISPR-Cas9 must also be made. Now, for CRISPR-Cas9 is a sort of a technology which edits the genes and which actually somehow it strives to create designer babies. So by editing a gene, you can create superhumans or humans of superior intellect. But the thought Wherefrom came the thought? The robots did not create us. We created the robots, and now the robots are trying to create further robots. However, now is it so hilariously funny that we accept that we actually we technologically we believed in technological determinism, and then we proceeded to technological neutrality, and then we proceeded to technological singularity. However, to my knowledge, to my understanding, you know, the basic rudimentary idea behind this is digital hegemony of a few nations, maybe one or two nations, and then or a group of people, maybe it may not be the entire nation. So it is this idea of technological determinism followed by technological neutrality, or even technological singularity that we face right now, is an idea, is an extension of a concept called digital hegemony, wherein, you know, a very superior, the superior most nations, or the nations with a very solid technological base, would exercise effective command and control over those who would not have that technological base because of economic and other strategic constraints. Now this was, I would not say that AI germinated all on a sudden. We took recourse to technological determinism all on a sudden. We took recourse to technological neutrality or singularity all on a sudden. No, it was a well thought out process, and now we are only the takers of the process. We have not much, we do not have much to do, however, to see that how AI curated content, or AI generated content, or AI assisted content, you know, are making rounds, and we are hobnobbing over this idea about what shall be the rights obligation approach, whether consent was granted, or whether we are actually sort of trying to not focus at the or to the rudimentary issues. We are trying to focus on the issues that emanated out of the rudiments. And we must understand, this is what I understand in this entire learning, going through this discourse, or learning through this discourse, that when ARPANET, for example, ARPANET was a digital hegemony in a way. So the ARPANET model was followed in many of the nations. It was created by the United States. Now, of course, it was not only the United States, many other technologically superior nations tend to exercise digital hegemony over nations who are not so technologically superior. For example, African nations, quite a few African nations are dump yards of the e-wastes, the electronic wastes, which are of course related to the technology and the technology enabled platforms. They are the waste created out of the technology enabled platforms and the technologies themselves. Now they are dumped in India itself. Is a good nation, wherein the superior most nations would actually give us something which is of a lesser, if not India is a dump yard as of now. What is indicative in this entire exercise is that we are in a highly digitally hegemonized world, wherein we have got nothing to so it is already the machine intelligence which has started determining human intelligence, and we have got nothing to do barring changing and tweaking some of the laws. For example, in the Indian context, we can tweak the Copyright Act. We can tweak the moral rights of an author within the meaning of Section 57 of the Moral Rights of the Copyright Act 1957. We can tweak Section 31 and make some changes in compulsory licensing. So we are a part of a hegemonized world, and we are only the takers and being forced. So in a way, in a larger way, we are not digital natives, we are digital immigrants. Because of the hegemony, we were forced to adopt to certain techniques which we otherwise would not have adopted, or would have adopted at a later stage, or would have adopted with some caution with some riders. Having said that, now this was the main base of my thought. That is the movement from technological determinism to a digital hegemonic system. Now, there are a number of ways which all of us, those people especially who are learned in science, would know that the artificial intelligence uses various ways, various methods, various types of means to generate content. It uses algorithms, it uses reasoning, it uses tutoring, it uses fuzzy logic, it uses neural networks and the like. So this is something which is understandable and is, of course, readily available on the near and dear friend Mr. Google. Now, the methods, of course, the methods are a bit nuanced. So the AI system adopts quite a few methods: the means end method, the problem reduction method, the generate and the test method, the analogy method. But finally, the part of employing a method is to sort of somehow find a solution to the problems, find a solution to what a human mind would think. For example, the problem reduction method, it uses a reductionist technique of and reduces and disintegrates the complex problem into simple problems, and then finds a solution and then replicates that solution to the other problems. And more or less akin is the mince end method, which is again it is again a technique for the purposes of closing your search, or having the point is that what do we want. And the artificial intelligence uses, actually it is whether we call it a need-based approach, or we may call it a need-based approach, because it is concomitant. The system works on human needs. So for example, if a search engine, if I want to find a Scopus indexed journal in a search engine, the artificial intelligence would read my mind, or maybe based on my previous searches, would create a database and would get me the content. Now, as I indicate, that this is purely technical. It uses a number of methods, and these methods are generally available in the public domain, not too much to be contested for. Now there are quite a few experiments. We all know in 2016, in Amsterdam, the Dutch people had harped on a very, very niche experiment on the next Rembrandt. That is, a famous painter, and millions of engineers were, not millions of engineers, actually millions of pixels were employed to sort of create, to recreate rather the next Rembrandt. So the purpose was to say that we can also, create content, and create content to that extent that the actual author created, a couple of centuries back. Apart from this, so there are a couple of many experiments actually going on in with reference to AI. One major experiment that we all know is a DeepMind experiment, which uses a C++ programming language, and they have created software which may generate music, and they earlier come up with gaming applications. So these are, and throughout the world there are multiple experiments that are being conducted, and now the question that comes is, we look at it from the point of view of 4 doctrines. We all know that copyright law, when content is created in a, through a human being, or through an assisted technology, or through a purely artificial intelligence device, we are faced with, so when the content is created, we are faced with a few challenges with reference to the content itself. Now, because my deliberations are all based on, of course, they're all based on AI and copyright. They are skewed they're skewed towards one thing, that is, what sort of a copyright violation, or what sort of a copyright issue does AI create? And to answer this question in the affirmative, let us dissect the 4 major theories of governing copyright laws. Now, for example, take the case, one of the erstwhile, even before the Berne Convention, or the Universal Copyright Convention, or even the Rome Convention 1961 dealing with neighboring rights, the erstwhile, the earliest kind of theory that supported protection was the sweat of the brow doctrine. So anything, any creation, which any original work, whether it is artistic, literary, dramatic, so maybe a sound recording, or any work, any original work must involve sweat of the brow, must involve some human involvement, must involve some amount of effort. So now, if we look at the at AI generated content from the point of view of sweat of the brow, the point that the important point that comes up to us is, can a machine be eligible to so because the machine is performing repetitive tasks, it is actually running on programs, on compilers and stuff like that, dependent on algorithms, but can it actually? So what is essential or critical rather to this sweat of the brow doctrine is the fact that that is the thought, is the forethought of the creator, is the forethought of the creator to create something new using his own labor, using his own sweat. That is understandable. So there is some effort which is put in behind every creation. But the thought, so will a machine think, for example, in one of the essay competitions that was held in Japan, an artificial intelligence device, and which is also posted in the WIPO website, I believe so, an artificial intelligence device had created an essay, and that essay had gone for a merit. I mean to say that that essay had won a prize. Now the point is that the essay was written by a computer. Yeah, so it was done through a compiler, and algorithms were run, and finally, the essay popped up. And right now there are AI assisted and AI generated content which are working on novels as such. So computers are writing novels, but the point is, from the point of sweat of the brow, which involves the forethought of the originator. So how, apart from the effort that is put in by the originator of the or the creator or the author, so can a machine give a forethought about his work? So the forethought was about the work itself and the ramifications of the work vis-a-vis when it hits the public domain. And then, for example, about 200 years back, when Adam Smith had written The Wealth of Nations, or David Ricardo had postulated his theory of rent, I do not know whether they had gone they had opted for a protection regime of their respective, or when, I mean to say, when John Locke had written the two treaties of the civil government. Now, was there, whether it was protected or not is a separate question, but there was a thought that I have put in the work and let the work be read by the people, and it is my work. So can that sense of ownership, that it is not a general sense of ownership from the commercial point of view. It is a very special, a nuanced sense of ownership of the work, which a machine would not be able to read at all. So resultantly, the sweat of the brow doctrine in copyright law is not in conformity with the AI generated content. The second doctrine, which was found rather in the famous case of Feast Publications versus Rural Telephones by the United States Supreme Court, if I'm not very mistaken, was the modicum of creativity doctrine. I'm sorry, I've written it wrong. It is creativity. It was a typographical error, and I beg your pardon, whosoever is listening. It is modicum of creativity doctrine, of course. And the modicum of creativity doctrine said that apart from, so any original work, only a piece of original work would not suffice. There must be an iota of originality. There must be an iota of creativity in the work. Now, creativity, of course. Now, creativity is as we all know, is a very subject. It is left to the subjective satisfaction of the people that what creativity is. So a movie, a Hollywood movie, for example, Star Wars, or for example, for that matter, E.T. Extraterrestrial, which was produced by Steven Spielberg, maybe one of the erstwhile movies wherein bits and pieces of artificial intelligence were used. And then in Jurassic Park, they had used a fair amount of artificial intelligence, at least when they had put the movie in, through videos and other channels. But the point is not about that. The point is about we are discussing about the modicum of creativity doctrine. So Steven Spielberg's Extraterrestrial, where of course it was an original thought to a large extent, but how far it was created is a critical question. So the Feast Publications case, of course, it has not stood the test of time, and even the American courts at a later point have deviated from the Feast Publications case, saying that it is very, very difficult to determine creativity, and so is the reason that we will adopt a median approach, and we will have a sweat of the brow plus some creation, so some original work and some creation which is understandable, which is a comprehensible creation. But the critical question facing us right now is, can it satisfy, can an AI generated content satisfy modicum of creativity? Maybe yes. Here I would say it is not entirely no, because novels written by computers or paintings done by computers, or say for example news stories cooked up by Google has been sort of doing this for some time now, so that is based on an artificial intelligence principle. And I would not say that the creativity is entirely not there in the AI generated content. It may have creativity, but it do not have the sweat of the brow, neither the sweat nor the thought. The third principle is the first use principle that we all know, that generally speaking, the first use principle says that whosoever uses the content first is the author of the content. That is the general, if legal fiction is to be used, any first use is deemed to be the use of or used by the author. So in a way, the first use principle. Now the point is whether the first use principle, AI generated content and a computer uses the document. Now, does it actually, because it becomes first of all, it becomes a authorless content. Now, can it be authorless? In the morning, I believe Professor Dr. Shambhu Prasad was pointing out to some of the recent judgments. In fact, one recent judgment of the United States court, wherein it was held that it must be a human to be eligible for a copyright protection. It must be, the person must be human, and maybe there are certain changes being brought in by the EU law as well, and because there are new dimensions being opened up in artificial intelligence, and it's while it is read in intersectionality. Now, the first use principle opens up the major question of an authorless or an authorful content. So can a bot, can a robotic artist, can a bot scholar, can a nano musician, these are the terms that I've coined. I'm sorry, I would not like to put it before the public domain, but for understanding purposes, for the sake of argument, if we may say that robotic scholars have created a very good, an excellent piece of writing on, say, on something, on say space research or space exploration or exploration of Mars, and those robotic scholars' work is put in the public domain, maybe, you know. So the point that I am trying to say is that, does it satisfy, does an AI assisted or AI generated or AI curated content abide by, does it abide by, or does it adhere to the principles of first use? It may, it may, so AI generated content may hit the the board scholars, the robotic artists may become the first users. However, questions remain with the reference to anonymity. Questions remain with the reference to the rights and obligations that are the obligations that are to be bequeathed, and to on whom the obligations are to be bequeathed. The fourth principle in this discussion on artificial intelligence and artificial intelligence generated content in terms of copyright is a fair dealing doctrine. So fair dealing doctrine, in some jurisdictions they use the term fair use, in some they use the term fair dealing, but no matter what the term is, the point is, can a bot, or can an artificial intelligence device or a program or an algorithm or a network use a content for fair purposes without violating, without infringing copyright? The answer to this question is partly yes. AI assisted or AI generated or AI curated content it may be used for fair purposes, for fair, as fair dealing, for fair use. However, so we have the ChatGPT issue coming up, and some of the jurisdictions are sort of camouflaged as to whether to use ChatGPT or whether to the contents of ChatGPT, and if they are to be, and whether that would be a fair use, whether that would tantamount to fair dealing. Now, these are interesting questions. These are very intriguing questions, rather. But however, on a prima facie basis, if there are three riders: the passivity rider, the due diligence rider, and I do not recollect the other rider. So this is, if these three riders are adhered to, I mean to say that if an artificial intelligence maintains due diligence while generating content, one, if the AI generated content is passive, is not too active to violate somebody else's rights, then the fair dealing would not prima facie be affected. The fair dealing doctrine would not prima facie be affected because of AI generated content. Now, so the sweat of the brow is not allowed. Modicum is allowed. First use principle is allowed. Fair dealing is allowed. Now, if three are allowed, so resultantly we get a feeling that we must allow AI. However, I have some of the observations to be made. Richa madam, am I overshooting time or am I well within my time? Richa madam, Priyanka madam, anyone of
Yes, sir.
you?
Yes, sir. Sir, you're audible, sir.
No, I am audible, but am I adhering to the time limit?
Yes, sir. Sir, you have another 10 minutes, sir.
Okay, my privilege, my privilege.
Yes.
So, we try to sort of look at AI generated content from the point of view of copyright laws. However, there are certain critical questions that remain. One of such question is the legal status of electronic agents. Now, the Electronic Communication Convention 2005, by Article 12, has conferred legal status to electronic agents. So resultantly, even electronic agents, so a RIA or a SIA, which we often find in websites, if they enter into any contractual obligations with us, with humans, or with other electronic agents, then such contracts will not be held unenforceable. Now, this is a big leap forward. I do not know whether it will lead whether it will lead us 2 steps backward. This is something which remains to be seen. But according legal status to electronic agents is a very, very critical step in this regard. And so we have got this concept of e-persents, electronic persents. But however, throughout the world, whether it is a company or a limited liability partnership firm, or even a sole proprietorship firm, the firm has to work through the proprietors and its agents and the directors, proprietors and agents are natural persons. So how can electronic agents be accorded the status of natural person, which is a big issue, facing the entire, the entire legal fora, if I may say. It is a problem which is posed. You are according legal status to electronic agents. You are according legal status to e-persons. You are according legal status to artificial intelligence. It is like according legal status to robots. So what if these these electronic persons or these robots create further robots? That is the problem. So we will not have any sway over those agents who are created by electronic agents. Another major issue with, so I have not focused on the other issues. There are strategic issues, there are social issues, there are economic issues, there are moral and ethical issues with reference to AI generated content. However, I have restricted myself to the legal issues. Another issue is the issue of digitized orphan works created by AI. Since there is if my data, because I worked on some data, in fact, this was one of the papers that I presented in IPR, so a part of it, in fact. So there is a lot of data which are digitized, which are orphan works, and these orphan works are created by AI. And some of these orphan works are somehow objectionable and sometimes defamatory as well. Now, the question is not about a defamatory content or an objectionable content. The point is, whom do we blame for if the content is, if it is not in sync, if the content is wrong, if it is half truth, if it is untrue, if the content is untrue, then who shall be held liable because of that? Shall the present discourses indicate that the intermediaries who are hosting, intermediaries, especially the websites which are hosting such digitized content, they are being held liable, very unfortunately. Now, Other issues would include the moral rights of an author. So, of course, the moral rights of an author, for example, in reference to the Indian copyright law, it is contemplated on Section 57. I read with Section 38B, which is about the moral rights of a neighbor. But the point is, the moral rights are, how can the moral rights accrue to an electronic agent or to a computer or to an algorithm? Now, there are issues about moral rights, and moral rights are those rights which may only and only accrue to natural persons. And there are issues with granting of copyright and other infringement issues in this entire discourses on AI generated content. Now, this is the last, this is what I feel is something that we must do as professors of law, as students of law, as social harbingers of social change. And the main thing is that what we are not doing is, what we have done is what we have seen. What we have not done is that we have not gauged that how many people have slipped slipped from the digital safety net. This is something that we have not calculated. To my knowledge, there are many people who are on the other side of the digital divide. I mean to say, there are many people who have not reaped the benefits of the AI generated content per se. So is it the time that we adopt the social justice model rather than the technological deterministic model, and include those people who are on the other side of the digital divide of the AI generated content? Another critical observation that I have in this deliberation is that AI generated content must clear the social impact assessment test and the environmental impact assessment test. We are already struggling with a lot of climate change. We are already struggling with issues such as climate refugees. We are struggling with issues such as green crimes. We are struggling with issues such as weather, climate, multiple issues circumscribing climate change. And these AI generated, they operate digitally, so they require a lot of power. And if they require power, they would bend on or they will take their power requirements from the fossil fuels, from burning fossil fuels, which would again strain the environment. We need to look at the issues of environmental sustainability and intergenerational equity before we adopt on a full-fledged basis or on a semi-fledged basis any form of AI generated content. And it must clear the social impact assessment and the environmental impact assessment, because to my knowledge, none of the countries across the world has done a social impact assessment or an environmental impact assessment of AI generated content, or the relevance and the role of AI in defining and redefining our systems and processes. Now, one major thing that had cut my mind is that in this AI, in this digital hegemonic world, or this world believing in digital hegemony, what we have shifted away from is the protection and promotion of traditional and indigenous knowledge. So in all possibility, so we need to adopt a defensive protection model for the promotion and protection of traditional and indigenous knowledge. Maybe such knowledge if the AI generated content is cleared, if the jurisprudence is cleared, maybe they may also take part, or their traditional knowledge may also get transpired at a later stage. But time is right that we use a defensive protection mechanism to promote and protect our traditional and indigenous knowledge. And of course, we must move away from the technological. We must understand that we are creators, so the created must not be the creators. This is what I believe. And some of you, at least some of you who would listen, may disagree, and I would be happy if people disagree. However, I do not think that time is right for India, or for that matter for any other nation states, to adopt a full-fledged AI generated content. And it must withstand the scrutiny. It must withstand judicial. It has not faced judicial scrutiny, unfortunately, and it must also face social scrutiny as well as judicial scrutiny. Some of the cases actually have been adjudicated with reference to artificial intelligence, but the cases are not enough. We need to adopt a more holistic learning by doing with approach. There is a difference between learning by doing approach. We learn and then do, and then we learn again. But the learning by doing with is that cumulatively we learn, and when we learn when we do something with someone. So we must adopt a learning by doing approach in order to ensure that to what extent AI generated content may be allowed and to what extent it must be disallowed. Thank you so much for the patient hearing, and my pleasure for being a part of this cohort today. Thank you.
Thank you so much, Rajat sir. I invite all the participants to please post your questions on the Q&A chat.
Are there any participants, by the way? Are there any participants?
Yes, sir, there are
Yes.
quite many participants.
Because actually I cannot see, because my PPT is open and I cannot
But
see.
there are more than 150 participants right now.
Okay.
So rather than the questions, there are certain comments that had been made in the chat. So if you have any comment to make on the same. So one of the participants has stated,
Chat is.
sir, I'll read that out for you. As one of the participant has stated, we have created the system and the culture and ethics. It is us who has done it. So she must have been talking in reference to the talk. So
Come again, please.
So
we have
we have
created the system and the culture and ethics. It is us who has done it. I would. It is, of course, we have done it. No other we can blame for doing it. But is it a question or an observation? This is what I wanted to know, because this is. We have done it. We have embraced artificial intelligence. But did we embrace artificial intelligence with caution? I ask all the people who are present. Did we embrace it with caution? Did we know what sort of a problems that it may lead to or give rise to at a later point? Did we for example, the questions of authorship. So who shall be the author of an unregulated content or an anonymous content? Who shall be the author? For how much time it will? Shall it be a sui generis system? Shall it be a formal system that we must follow, within our normal, by harmonizing our laws and policies? So if you say that we have created a system and the culture and ethics system, of course, we have done so. But did we do so diligently? That is our question. I do not think that before embracing AI, whether in the field of IP or in the field of other neural networks or in other fields of human inquiry, when we apply IP, I believe that we have not done it with caution. Actually, we did not do. Now there are multiple issues that have been posed, but there are not too many answers. For example, the Copyright Act is oblivious to artificial intelligence. Because I believe Richa madam would also accept, she is also an IPR faculty like me. The entire act is oblivious to artificial intelligence, to the principles of artificial intelligence.
So true, sir, because artificial intelligence relatively, it is finding its place currently more. So, and moreover, there have not been many amendments. That is what I think we lack as a system, that we do not amend our acts in a timely manner.
No, actually, ma'am, another point which is because it is only in the last decade that so many changes have happened.
Yes.
So, for example, if you take the curator approach that I had stated, the Dutch experiment, the Google experiment. So these are about decades. This happened about decades back. The Dutch experiment about 6 to 7 years back. And right now there are a lot of experiments that are going on, but environmental impact assessment is not done. That is, and for any engineering project, this is a ground rule in engineering. To pass any project with reference to engineering or technology, it has to pass the environmental impact assessment.
Sir, though, if I remember correctly, then after the Bhopal gas tragedy, they have made, such a system. They said that impact analysis has to be done before any project to be passed on. But again, I think it comes down to enforcement, how things are being implemented. So we do have rules, we do have regulations at times, but they are not being implemented in a proper manner. That is also one of the lacunas in the system.
Absolutely, absolutely. And there is another observation, sir, in case there are more slides you're speaking on, is there on the PPT, please keep sharing those slides too. No, this is a general observation. India is also a dump yard for many nations. Read in the art, that is absolutely correct. That is what I have also made a passing reference to, that India is a dump yard. And of course, India is a growing hub of artificial intelligence content or AI generated content. It is becoming a hub, but simultaneously it is also a dump yard, which actually takes our theory back to the digital, I mean to say the digital hegemony theory, actually. So it can only be a dump yard because we are a part of the digitally hegemonized world in a way.
Priyanka ma'am, there's one question.
One more question. Yes, ma'am. I was just going to read that out. So there's one question, sir, from Devendra Singh, asking that we all currently said we are trying to avoid ChatGPT, but I think it is not about avoiding, but how to use or make the regulation so it will work in a better way. Your comments.
Fair enough. That is a ChatGPT. There is a lot of hue and cry about ChatGPT. The point is, if you are regulating it, thinking about regulating the terms in terms of content of the ChatGPT, then we are actually moving a step forward, without making 2 steps backward. what I believe is, this is my personal take, I may be wrong. What I believe is that before entirely before having a or creating a jurisprudence, let us somehow take a few steps back and see, for example, accordance of legal status to electronic agents, electronic persons, whether that is valid, whether it frustrates the authorship ideals, whether it is in consonance with the moral rights. So these things would come possibly first, and regulating ChatGPT, in terms of content, that is all the more required, because right now what has happened is, so sir is right. Right now, what has happened is a lot of content has already flown in, and there is possibly not a there is no chance of going back, rather than having a forward-looking approach and then regulating it in terms of content and format, if I may say.
Right, sir. Um, Richa ma'am, are there any more questions?
No, ma'am, I can't see any more questions here.
Okay.
So we are, so you have finished well within time. So
Yes.
the session has been like really time encompassing. So we haven't moved a minute even.
I entirely spoke extempore. Actually, I took reports to some of the slides, but this is what I generally teach in my classes as well, that we must think about AI and AI generated content, and I believe I have been able to put my views forward.
Yes, sir. And so the discussion that you delved in, it was like so vast, from digital hegemony to, you have also discussed the theories of copyright. So I think it has given a lot of food for thought to our participants.
Thank you so much, ma'am.
Thank you so much, sir.
Thank you, sir, for giving us the fodder to think about for the coming days.
Thanks, ma'am.
So our next guest, Dr. Anirudh Vashisht, is here with us. Welcome, sir.
Thank you, ma'am. Thank you. How are you? Good
Hi,
afternoon.
sir. Good afternoon, sir. How are you?
I'm fine. Thank you.
Good afternoon, sir.
Good afternoon, ma'am.
Good afternoon, sir. For all the participants, I'm welcoming our next speaker, Dr. Anirudh Vashisht. He is currently working as assistant professor in Amity Law School, Amity University, Noida. He has completed his PhD on unconventional trademarks from Jamia Islamia University, and has completed his LLM from Indian Law Institute, ILI, in 2010, and LLB from Campus Law Center, Delhi, in 2007. And he's having a rich research experience and has published research papers in leading journals and presented many papers in different seminars and conferences. I welcome, sir. We are really pleased to have you here. Thank you so much for joining us, and we are eagerly looking forward to your session, sir.
Thank you,
The
ma'am.
floor
Thank
is
you.
all yours.
Can I share the screen now?
Yes, sir. Yes, sir. Please.
Is it visible?
Yes, sir, it's visible, sir.
So can I start?
Yes, sir. Yes, sir. Please, you can.
So good afternoon, everyone. And first of all, thank you for giving me opportunity in speaking in this value-added course. And my topic is trademark and branding in AI application. So basically, how AI, artificial intelligence, it is affecting the trademark and branding laws. So first, we will discuss what is the meaning and what is the objective of trademark law. So first, we will discuss the trademark law, then the AI, and then how the AI is affecting the trademark. So definition of trademark. So trademark in Indian law, it is defined in the section 2, clause 1 ZB. Trademark is a mark that is capable of being represented graphically and capable of distinguish the goods and services of one person from those of other, and include shape of goods, their packaging, and combination of color. So trademark basically means a mark which can be presented graphically. It can be any mark, name, logo, signature. It must be capable of graphical representation, and then it must be capable of distinguish the goods and services of one person from those of others. So this is basically the basic objective of trademark law, or the trademark. When you see a mark, like suppose you see a Nike mark on any product, so you can distinguish that this belongs to the company Nike. So this is basically the objective of trademark law, to distinguish the goods and services of one person from those of others. Then a mark, basically, mark includes a device, brand, heading, label, ticket, name, signature, word, letter, numeral, shape of goods, packaging, or combination of color, or any such combination. So any logo, any signature, any name, any label, heading, it can be a trademark. Now, from this, we can analyze the definition that what is the trademark. Basically, trademark means a mark that can be any device, heading, brand, ticket, signature. And second thing, it must be capable of it should be capable of being represented graphically. So it must be capable of presenting on the paper. Though there are some unconventional trademark also, but mostly the trademark you will find they must be capable of the law on unconventional trademark is developing. It is not, you cannot say that that very frequently you will find the unconventional trademark like sound, smell, or taste trademark. So conventionally, the trademark means a mark can be presented graphically. And the third thing is that it must be capable of distinguish the goods and services of one person from those of others. So this is, like we have already discussed, this is the basic object of trademark, to distinguish or to identify the source of origin of goods and services. Then shape, combination of color, and packaging can also be protected as a trademark. So these are some famous trademark: Yahoo, Adidas, CNN, Nokia, Toyota. Then what is the function of trademark? So first function of the trademark obviously is to identify the origin of the source of origin of the goods and services. Okay? Like we have discussed Nike, or you see Apple. So the moment you see that mark, you can identify the source of origin of goods and services. Then the second purpose is to guarantee its quality. Obviously, you will the purpose of trademark, like the company, they are advertising, they have developed their goodwill, their reputation, their trademark for several years. Say they are providing you the quality goods and services, and they have formed their reputation. So it will guarantee. So like when you are buying an Apple phone, so obviously you will think that it must be of some quality. Or you are buying the Nike shoes, so you can say that it must be of some quality. So it guarantees the quality of the goods and services. Then it advertise the product also. The trademark represent the product. So how you will advertise the product if you do not have any trademark? So whenever you are seeing any advertisement, you can recognize the advertisement based on the trademark. You can say that this advertisement belongs to this company because there is a trademark. Then it creates the image of the product in the minds of the public, particularly to the consumer or the prospective consumer of the such. So obviously you will have this in mind. The moment you see that mark, you can recognize that this belongs to this particular company. So these are basically the basic function of any trademark. So we can take this example, like there are two bottles and there are two different shampoo in these two bottles. One is Cleaning Plus and other is Painting. Can you identify which bottle contains which shampoo? So obviously not, because there is no trademark. But if I show this picture, so now you can recognize where, because there is a trademark, that this shampoo on the left is Painting and the shampoo on the right is Cleaning Plus. So this is basically the basic function of trademark, is to identify the source of origin of goods and services. Now we will discuss the artificial intelligence. So artificial intelligence, this term basically it was used first by the John McCarthy in the year 1955. He defined the artificial intelligence as the science and engineering of making intelligent machine. So now before 1955, in 1950, Mr. Turing, the Professor Turing, he raised this question in his presentation in a paper, that whether the machine can think. And then further in 1955, this term was used first by John McCarthy in a conference, and where he defined the AI as the science and engineering of making intelligent machine. Means the machine that can think. Like obviously there is always a question whether the machine can think like a humans or not. So it all started in the year 1955. In simple term, we can define the artificial intelligence as the ability of the digital computer or computer controlled robot defined to perform tasks commonly associated with the intelligent being. So like anything which can be done by the human being, can it be done by the machines? So term is frequently applied to the project of developing system endeavor, the intellectual processes, characteristics of humans, such as the ability to reason, meaning, generalize, or to learn from the past experiences. So this is basically, it was earlier associated with the human beings. Like human being, they can think, and they can generalize, they can discover. So everything that is associated with the human beings, can it be done by the machines? If it can, then it is obviously it is artificial intelligence. Or artificial intelligence involves using devices to do things that traditionally require human intelligence. So obviously, like if a machine is thinking, it is generalizing, it is using its past experience. So what it is doing, it is working as the mind of the human being. So AI can process large amount of data in a way that human cannot. The goal of AI is to be able to do things like recognize pattern, make decision, and judge like human. So basically, artificial intelligence is nothing but basically you are training the machine that it can think like a human. It can think, it can generalize, it can experience like a human being. Now, type of artificial intelligence. The artificial intelligence, basically it can be divided basically into two parts: weak AI and strong AI. So weak AI basically means the artificial intelligence which can perform only a particular function. So like you must have used the Siri in Apple, Alexa, and the Google Map. So they will do a particular thing. They have been trained to do a particular thing. So weak AI, it is also known as the narrow AI or artificial narrow intelligence, is AI trained and focused to perform specific tasks. Weak AI drives most of the AI that surround us today. Narrow might be more accurate descriptor for this type of AI, as it is anything but weak. It enables some very robust application. Weak AI example includes Siri, Alexa, and other smart assistant, self-driving cars, Google search, conventional boards, email spam filter, Netflix recommendation. So these all are the weak AI. Like for example, suppose you must have played the Ludo game or the chess game. So they have been trained to do or to perform that particular work. So if you tell the AI which is playing the Ludo, if you tell that AI to play chess, it will not be able to play because it has been designed to do a particular specific work, that is to play Ludo. So that is the weak AI, because it can only perform a single specific function. Now, on the other hand, strong AI basically means an AI that can perform the multiple tasks. Okay, so even though this concept is mostly theoretical, and we have not able to use strong AI in robots and all, but you must have seen the movie like Robot, Matrix and all. They are basically the example of strong AI, where the robots, they are doing the multiple tasks. They are thinking as a human. They are taking the decision. They are doing the multiple tasks. So that is basically the example of strong AI. So strong AI is made up of artificial general intelligence or artificial super intelligence. Artificial general intelligence or general AI is a theoretical form of AI where machine would have an intelligence equal to humans. It would have a self-aware consciousness that has the ability to solve problems, learn, and plan for the future. Artificial superintelligence, also known as superintelligence, would surpass the intelligence and ability of human brain. While strong AI is still entirely theoretical with no practical example in use today, but that does not mean AI researchers are not also exploring its development. In the meantime, the best example of SI might be from the science fiction movie of Rajnikant, Robot. So in that movie, you must have seen that the Rajnikant, he developed one robot, and later on it poses the threat to all the human beings. It was basically destroying the all the human beings, including the person who has developed that robot. Now, artificial intelligence application, there are different applications by which the artificial intelligence will work, like the speech recognition. So, like you must have used the Siri, or you must have used the Alexa by Amazon. So they can recognize your speech. You will say something like, what is the temperature? They will tell you the temperature. Like what is the traffic condition in your city? They will tell you the traffic condition in the city. How much India has scored in today's match, they will tell you the score of the match. So they will recognize your speech. So it is also known as the automatic speech recognition, computer speech recognition, or speech to text. And it is capability which uses natural language processing to process human speech into a written format. Many mobile devices incorporate speech recognition into their system to conduct voice search like Siri, or provide more accessibility around texting. So they will recognize your voice, and on that recognition, they will give you the answer of the question that you have asked. Then customer services, they basically give you the like some on some side you will see the fact frequently asked question. When you click on the question, they will give you the answer. So that is basically the customer service. So like the auto-generated message on WhatsApp, Facebook, they all are the example of customer service, which is using the artificial intelligence. So online virtual agents are replacing human agents along the customer journey. They answer frequently asked questions around topics like shipping, or provided personalized advice, cross-selling product, or suggesting sizes for users, changing the way we think about the customer. Commerce side with virtual agents, messaging apps such as Facebook Messenger, and tasks usually done by the virtual assistant and voice assistant. So, I have read in one article that in future, when you will throw the empty package of any, like suppose you have already consumed the biscuit and you are throwing the empty package in the dustbin. So that dustbin will scan the scan code. It will scan the code, and it will order that biscuit, and it will pay the online, and it will be delivered to your home. So the moment you will throw the empty package of any goods in the dustbin, it will scan and it will be ordered automatically, and payment will be made automatically. So in future we will be able to do that also through the artificial intelligence. Then computer vision, that is basically when you upload any picture on Facebook, like suppose you have uploaded a picture with your friends on Facebook. So you must have seen that they will give you the recommendation to tag your friend. So even watching, or even like you have just uploaded the picture, you have not tagged anyone, but they, based on that picture, they will give you the suggestion that this is your friend, this and that, and you can even tag that friend. So that is basically computer vision. So this AI technology enables computer and system to derive meaningful information from digital images, videos, or other visual inputs, and based on those inputs, it can take action. This ability to provide recommendation distinguishes it from the image recognition task. Powered by convolutional neural networks, computer vision has application within photo tagging in social media, radiology, imaging in healthcare, and self-driving car within the automotive industry. So even the self-driven car is using this AI of computer vision. Then recommendation engine. So obviously, when you when you log into Google or to YouTube, you will find that it will show you the recommendations. So like for few days, like past few days, because I'm searching for this AI and everything. So YouTube, it's showing me the videos relating to AI. So based on the past experiences, what I have searched, what I was looking for, it will give me the recommendation. So using past consumption behavior data, AI algorithm can help to discover data trends that can be used to develop more effective cross-selling strategies. This is used to make relevant add-on recommendations to the customer during the checkout process for online retail. So this is all about recommendation engines. Then automated stock trading. So based on the AI, it will tell you which stock is performing well and which will perform well in the future also. So this type of recommendation will also be provided by the automated stock trading. So designed to optimize stock portfolios, AI-driven high-frequency trading platform make thousands or even millions of traders per day without human intervention. So without human intervention, you can do the automated stock trading. So these are basically the different AI applications. Then history of AI. So history of AI, like we have discussed, it all started in 1950 when Professor Turing, he published an article, Computing Machinery and Intelligence. In that paper, he proposes the answer to the question, can machine think? And introduces the Turing test to determine if a computer can demonstrate the same intelligence or the result of the same intelligence as human. The value of the Turing test has been debated ever since. So he has developed one test, Turing test. Okay? If a machine can think like a human, so you can say basically it is the artificial intelligence. Then in the 1956, John McCarthy, basically he first used this term artificial intelligence in the conference, and he defined the artificial intelligence. This Mr. John McCarthy is also known as the father of artificial intelligence. Then in 1997, IBM Blue beats then world chess champion Gary Kasparov in a chess match. So like Ludo, chess, it was all developed in around 96, 97. So this IBM Deep Blue, that is also an artificial based application which beats the then champion Gary Kasparov in the chess match. Then in 2022, the OpenAI, that was basically founded by Sam and Elon Musk in 2015, that basically launched the Chat GPT, which as you know, I think all of you must be aware about this Chat GPT, and it reached the 1 million user in just 5 days. So the Facebook or the Instagram, like we are using it for years, the Facebook, it took around 10 months to reach 1 million mark. And then to Instagram, it took around 2.5 months. And then the Netflix, it took around 3.5 years to reach this 1 million user mark. But this Chat GPT, it takes only 5 days to reach 1 billion mark, and it is now obviously it is more than 100 million users now, and it just took the Chat GPT a few months to reach that mark. Then in 2023, Microsoft launches an AI-powered version of Bing. So it is basically a search engine built on the same technology that powers Chat GPT. Now, interestingly, the Microsoft also invested 1 billion in 2019 in OpenAI, and then in 2023 they have invested 10 billions in OpenAI, and now they are incorporating the same platform in their powered version, Bing. Then obviously 2022-23, Google announces Bard and competing conventional AI. So there is a tussle going on between the Google and the Microsoft. And Google, they announces Bard, a competing conversational AI. Then 2023, OpenAI launches GPT-4, its most sophisticated language model yet. So you can say it is the advanced version that they have launched in the year 2023. So now we will discuss some examples of artificial intelligence. So first is Chat GPT. So I think everyone must be aware about the chat GPT, and if there are students, I'm sure that many of the students, they are using this chat GPT. So now what is it stand for? Chat GPT means chat generative pre-test transformer. Okay. So it basically means what you are doing, you are training the machine. You are training the machine, and you have trained the machine in such a way that it will be able to give answer to your question. It can think like a human being. So Chat GPT, it was developed by the company OpenAI. It was started in the year 2015 with Sam Altman and Elon Musk. They were the founder of this company, but later on, Mr. Elon Musk, he has resigned from this company because he was more focusing on his company Tesla and SpaceX. And in 2019, Microsoft, they have invested 1 billion rupees in this OpenAI. And then in 2023, they have invested around 10 billion in this OpenAI that introduced Chat GPT. So what is this Chat GPT? It is an artificial intelligence chatbot capable of producing written content in a range of format from essay to code and answer to simple questions. Now launched in November 2022 by OpenAI, ChatGPT is powered by a large language model that allows it to closely emulate human writing. So it can write, it can give answer, it can give answer to your questions, it can solve your homework, it can solve any maths problem, and in some cases it can give you legal advice, it is giving you medical assistant. So it is doing everything. And in some cases, like if you say like you want to write a script for a movie, it will give you the script also. Or you want to write an essay on any topic, like say global warming, so it will give you the exact paragraph. Suppose you have written 100 words, so they will give you 100-word paragraph on global warming. So this is what this Chat GPT is all about. So can anybody tell me how it is different from Google, this Chat GPT? Anyone? So basically, what is the difference between this Chat GPT and Google? Like suppose if you're searching something on the Google, like suppose you want to write a paragraph on global warming. Okay, so you are searching it on the Google. So Google will give you thousands of articles that is written on global warming. But this Chat GPT, it will give you the exact paragraph. So like suppose if you want a paragraph of 300 words, so this Chat GPT will give you the exact paragraph of 300 words. So in Google, they will give you the different articles or the books that is on the topic global warming, but that give you this Chat GPT will give you the exact the paragraph that you want. But there is one difference also, that Google will give you the sources also, but Chat GPT will not be able to give you the source. It will use it intelligence. It will give you the paragraph, but it will not tell you the source from where it has written the paragraph. So this is basically the basic difference between Chat GPT and the Google. Then you must have used the second example of artificial intelligence is Google Maps. I'm sure you must have used this Google Maps in when you are searching any location, or you're not able to find any location and all, you will use the Google app. So Google Maps uses location data from smartphone as well as user reported data on things like construction and car accident to monitor the app and flow of the traffic and assesses what the fastest route will be. So based on AI, it will use the AI, it will use your current location, and it will tell you the best route that is available. Then smart assistant like Siri and Alexa, obviously they use the speech recognition. Based on your speech, whatever you have asked, they will give you the answer. So these personal assistant like Siri, Alexa use natural language processing or NLP to receive instruction from user to set reminders, search for online information, and control the lights in people's homes. So like they use this application, and they can even control the lights in the homes, the fan and all. So in many cases, these assistants are designed to learn a user preferences and improve their experience over the time with better suggestion and more tailored responses. So like the more you are using these applications, the better they will become. So obviously, because they are learning and from your searches and whatever you are feeding, so they will learn from that, and the more you use, the better they will become. Then Snapchat filters, this also we use very frequently. So it can recognize your movement, like it can give you mustache, it can give you beard, it can make you bald, it can give you makeup. So whatever you want, the Snapchat filter will give you. So again, they are using the AI and they are recording your movement also. So Snapchat filter use ML algorithms to distinguish between an image subject and the background, track facial movement, and adjust the image on the screen based on what the user is doing. So sometimes you will like show your tongue, it will give you the very big tongue and all. So that is all in the Snapchat filters. So then self-driving cars. So Tesla, as you know, they are making the self-driven car, and the plan is that by 2015, all the cars in America, they will be self-driven. And if you want to drive your car by yourself, then you will have to pay extra. So again, they are using that AI. So self-driving car are a recognizable example of deep learning, since they use the deep neural network to detect objects around them, determine their distance from other cars, identify traffic signals, and much more. Okay, but again, you have to keep in mind there is a limitation. So if you have designed the car based on the road condition of America, so it will not be able to run in India, because whatever you are feeding in the AI, it will perform on that only. So it will work, or it will run on. It will be able to run only in America, because you have fed the data of American roads. Now we'll discuss what are the some advantages and disadvantages of artificial intelligence. So first, we will discuss the advantages. So first is the good. It is good at detail-oriented jobs. So in some cases, it was found that basically they are able to diagnose the diseases like breast cancer and melanoma better than the doctor itself. So AI has proven to be good or better than doctor at diagnosing certain cancer, including breast cancer and melanoma. So basically, it is goal-oriented job. It will perform the goal-oriented job very efficiently. Then it reduces the time for data-heavy tasks. So AI is widely used in data-heavy industries, including banking and security, pharma, and insurance, to reduce the time it takes to analyze the big data. So you will just feed the data and it will analyze, it will make it into the Excel sheet and all. So obviously, if any human being is doing that, it will take some days or months to arrive at a particular decision or to make the Excel sheet, but it can perform all these functions in a few seconds. So financial services, for example, routinely use AIs to process loan application and detect fraud. So these things can also be done using the AI. Then saves labor and increase productivity. So an example here is the use of the warehouse automation, which grew during the pandemic and is expected to increase with the integration of AI and machine learning. So obviously it will save your labor, your time, and it will increase the productivity. Deliver consistent result. So this is very important. It will consistently perform well. So like suppose if you are a doctor, there may be a chances of any mistake and all, but the machine, they will they will work efficiently and they will work without any error. So they will give you the consistent result. So the best AI translation tool deliver high levels of consistency, offering even small businesses the ability to reach customers in their native language. Then it can improve customer satisfaction through personalization. So obviously, because AI, it can give you the exact result that you want. So it will improve the customer satisfaction, and it will give you the personalized answers also. So AI can personalize content, messaging, ads, recommendation, and website to individual customers. So like whenever you are using the WhatsApp or Facebook Messenger, so it will show you like whether you want to use any icon or different pictures and all. So that is also the example of AI. Then AI powered virtual agents are always available. So obviously they do not need any rest and all. They can be available 24/7 without any break. Isn't it? On the other hand, if there is any human being, like obviously it needs some rest. It cannot perform 24/7. It will take the breaks and all. But this AI, it can work 24/7 without any break. So these are basically the some of the advantages of artificial intelligence. Then there are disadvantages also. So disadvantages of artificial intelligence, high cost. So this is basically because like initially when you remember the mobile phone, it was introduced, it was very costly. So now because obviously it is a new technology, so it is very costly. So every organization cannot use artificial intelligence, even though by 2030, most of the organization, around 75% organization, they will be using the artificial intelligence. But right now, if you're saying that, obviously it is very costly, like all the organization, they cannot use this technology. So the ability to create a machine that can stimulate human intelligence is no small featuring. It requires plenty of time and resources and can cost a huge deal of money. AI also needs to operate on the latest hardware and software to stay updated and meet the latest requirements, thus making it quite costly. So it is quite costly right now, but in future it may like any other application, it may the cost may reduce, but right now it is very costly. Then there is no creativity. So some researchers say that the big disadvantage of AI is that it cannot learn to think outside the box, because like we are saying, it will think like whatever, how you have trained it, what data you have feed in that application, it can think in that way also. So AI is capable of learning over time with pre-fed data and past experiences, but cannot be creative in its approach. Even though like they now AI, they are using their intelligence, they are using their creativity, but it is not that advanced that it can use the creativity that will be done by any human being. So classic example is the bot will who can write Forbes earning reports. These reports only contain data and facts already provided to the bot. So although it is impressive that a bot can write an article on its own, it lacks the human touch present in the other Forbes articles. So like obviously it can write an article on any topic, but it only use the already data that is already that you have feed in that application. Then unemployment, that is basically the very major, you can say, drawback of using the artificial intelligence in different organizations, that every researcher or scientist, they are saying that it will increase the unemployment. So like we are saying that by 2030, around 75% organization, they will be using artificial intelligence in some form or the other. So there is a danger that there will be unemployment. So like we are saying, it can solve your problems, it can give you legal assistance, it can give you medical assistance, and so there is a possibility that there will be unemployment. Earlier it was, when it was introduced AI, it was like there was the apprehension that first it will unemployed the blue collar job, but what happened is totally opposite, and the creative job, first it is taking the creative job. So there is a danger that it will create the unemployment, because obviously that the work that is done by 10 people, the AI, the artificial intelligence, the robot, it will do. Only one robot can do the work of the 100 people. So there will be unemployment. They are giving you the legal advice, they are giving you the medical assistance, they are creating the pictures on your behalf, and they are composing the songs on your request. So if you want to write a script, they will write a script. So if you want to have any shairi, any ghazal, they will write on their own behalf. So obviously it will create the unemployment. So one application of artificial intelligence is a robot which is displacing occupation and increasing unemployment. Therefore, some claim that there is always a chance of unemployment as a result of chatbots and robots replacing humans. So for instance, robots are frequently utilized to replace human resources in manufacturing businesses. In some more technologies advanced nations like Japan, this is not always the case though, as it creates additional opportunity for humans to work while also replacing human in order to increase efficiency. So, but there is other way around also, like when computer was introduced, it was felt that it will create the unemployment, but what happens is exactly opposite. It created the millions of jobs. So that can happen with the AI also. Obviously, it will replace some jobs, but it will also give the opportunity for new jobs also. Then it will make the human lazy. So obviously, when everything is done by the robot or artificial intelligence, it will make you lazy. So everything will be done on your speech, or you will not be required to move. So the humans, they will become lazy. So an application automate the majority of tedious and repetitive tasks. Since we do not have to memorize things or solve puzzles to get the job done, we tend to use our brain less and less. This addiction to AI can cause problem to future generation. So like earlier, we used to remember when the mobile phones were not there, we used to remember the phone numbers of our friends, our family members and all. But because now we have the mobiles, every number is faded. So now we don't remember the number. Even sometimes some people, they do not remember even their own number. So it will obviously, it will make you lazy. You will not be using your brain frequently because everything will be done by the robot or the AI. Then no ethics. The AI, it does not know any ethics. It does not know what is honesty, what is dishonesty, what is obscene, what is not obscene. So there is no ethics in artificial intelligence. So ethics and morality are important human features that can be difficult to incorporate in AI. The rapid progress of AI has raised a number of concerns that one day AI will grow uncontrollably and eventually wipe out humanity. So this movement is referred to as the AI singularity. So it does not know any ethics, what is right, what is wrong, what is honest, what is dishonest. So there is no ethics in AI. Then it is emotionless. So if you have seen the movie Robot, so when Rajnikant, he initially developed that robot, and it was asked to save a girl from the fire. So she took the girl, it saved the girl from the fire, but it brings that girl without clothes in the public. And after seeing that, the same girl, it committed suicide. So obviously, because it is emotionless, it does not know the human emotions. So since early childhood, we have been taught that neither computer nor other machines have feelings. Humans machine as a team, and a team management is essential for achieving goals. However, there is no denying that robots are superior to humans when functioning effectively, but it is also true that human connection, which form the very basis of teams, cannot be replaced by computer. So in the movie, in that movie, we have seen that the robot, it is fighting with 20 humans, it is beating the 20 humans and all. But again, there is no emotions. And then it lacks the improvement part, no improvement. So machines can only complete tasks they have been developed or programmed for. If they are asked to complete anything else, they frequently fail or provide useless result, which can have significant negative effects. Thus, we are unable to make anything convincing. So like Chat GPT also, earlier the data till 2021 was fed in Chat GPT. So it will give answer that is based on the data till 2021, I think. Now they have updated it. So it will need to be updated every time to give you the auto to use the new data. Otherwise, it will give you the same old data. There will not be any improvement at all. So I think you must all aware about this person, Mr. Stephen Hawkins, one of the, you can say, the finest physicist of all time. Now Hawkins, he already conflicted with the AI. He basically warned that the AI, it is posing a threat to the very existence of the human being. So from Professor Stephen Hawking, one of the Britain's preeminent scientists, has said that effort to create thinking machine pose a threat to our very existence. The same thing happened in the movie Robot, when the robot, that the name was Chitty, it took over from the developer himself, and it was posing the threat to all the human beings. So he told the BBC that the development of full artificial intelligence would spell the end of human race. Hawking cautioned against an extreme form of AI in which thinking machine would take off on their own, modifying themselves and independently designing and building ever more capable system. Human bound by the slow pace of biological evolution would be tragically outwitted. Now you must be thinking that we are talking about the robot and they will take over the human beings and all. So you just remove the electricity, there will be no power. But like in the movie, you must have seen that even if you plug off the electricity, but the robot, the AI will be capable that they will take the energy from different resources. They will take the energy from whatever sources that is available. So it is not that easy. So if you are like developing the strong AI, if you're developing the robot, it can even pose a threat even to the very existence of human being. Now, how it is affecting the trademark law. So this is all about AI. We have discussed about the trademark and then artificial intelligence. So now how AI influencing on the buying decision, or how it is conflicting with the basic objective of trademark law. So you must have seen in earlier time how we used to buy the goods. We will go to the particular shop. There will be one person who will telling about the goods and bads of any particular product, and then you will buy the product. Then later on, with the invention or with the development of self-service store and with the development of trademark law, you will go to the particular shop, like say suppose Geo Mart, or you will go to any big bazaar shop, self-service store. You will pick the article based on the reputation. So you will go to, like suppose you are going to Reliance or to big bazaar, you will pick the Maggie because you already have a faith that this product will be of some quality. You will take the data namek and all. So this role of the filter or the mediator was taken over by the self-service store. So earlier we used to go to the shop. There will be one filter. There will be one person mediator who will tell you about the quality, the good and bads of the product, and based on that you will buy the goods. But later on, because of the development of trademark law and the self-service store, you will go to the self-service store and you will pick the article by yourself based on your taste and interest and the faith that you have on a particular brand. So now what the AI is doing, again, they are like, suppose if you're going on any online site like Amazon or Flipkart, you will, like you are writing like you want a mobile under 20,000 rupees. So it will give you different options. So again, they are working, they are working as a filter, as a mediator. They are giving you 10 options. There's these are the 10 best phones that are available under 20,000. So we are again, we are at the same position like we earlier. There was a mediator who will tell you about the good and bads of any particular product. Because so they will give you certain options, 10 options. Say suppose they have given you that the company or the site will give you the 10 options. They will tell you the good and bad, advantage and disadvantage of that product, and based on that you can select which product or which mobile phone you want to buy. So although the use of AI application by consumer is still relatively limited, most consumer will have used some form of AI application such as the product recommendation system appearing on Amazon.com and other online retail platform. In this context, the AI application effectively act as a filter between the consumer, the product, and the brand, making unique recommendation to the consumer on the basis of past purchasing decisions. Now, what is the dilemma? Now, dilemma is basically that we are thinking that we are getting the options, but in some sense they are limiting our options. So, like suppose they are showing you only 10 best brand, okay, based on the past reviews or whatever. They are giving you the 10 brands. So, in some sense, they are limiting your 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 uh, your power or your right to choose. So online retailers are employing AI-based algorithm system to make prospective recommendation to buyers. In doing so, they read and formulate data based on our search histories, preferences, buying profiles, and countless other minuscule details. It is imperative to note that through this employment of AI-based system, the very essence of trademark is being left pretended. Now, what is the role of the trademark? Like earlier, we have discussed that the role of the trademark is to identify the source. Now, obviously, the reputation or the brand name, it cannot be developed in one day. Okay? It took years to become the famous or to become or to have your reputation, your trademark. It took several years to become famous. So now, but now they are suggesting you like when you go to the Amazon.com, they will give you different suggestions. Okay, so obviously it is making the trademark law redundant. So AI can be well assessed, abolible tool to deprive customer of their discretion in choosing the product of their choice. So obviously they will have influence on your mind when you see that what are the views. Like suppose you are searching a phone that is under 20,000 rupees, it will give you, like suppose Amazon, they're giving you 10 recommendation. You will see the reviews of the customers. Okay? So obviously it will have influence on your discretion to choose. So it is intriguing and but terming at the same time to see that although the customer is under the impression that he is seeing the product of his choice or is exercising control over his decision-making process. However, most consumers are unaware of this limitation set to their choices. So it is basically setting a limitation to your choice. Though we are thinking that we have been provided with 10 mobiles or 15 mobiles, but in real sense, it is limiting your uh, discretion to choose. Then, for example, suppose if a person uses one of these AI-based system to order a particular product, and the AI chooses the best possible option based on the data collected through monitoring the choices and preferences of the user. Now, what determines the ability of such decision? If the bought product turns out to be counterfeited, or there is a substantial discrepancy in the desired quantity or quality of product thus ordered, would these tech giants like Google or Amazon will be liable? So this is basically the problem, like based on their recommendation, based on the reviews. Now, suppose you have ordered something, you ordered a mobile, but later on it was found to be counterfeited. So whether these companies like Amazon, Flipkart, Google, whether they will be responsible or not. So that is basically the issue. So more importantly, the foundational element of trademark law, like likelihood of ambiguity, unwary customer, imperfect recollection, etc., remain unaddressed in this new application of AI. These are worrying concern and demand pressing answer in order to justify this convergence of AI and trademark law. So because now what is the role of trademark? Like suppose you're buying the Apple phone, it has a trademark, it has a reputation. So you have faith that whenever you're buying the Apple phone or Samsung phone, that it must be of some quality. But like suppose if you are just buying the phone based on the recommendation of these Amazon or Flipkart, so you will not be sure that it will be of some quality or not. Then again the question comes whether they will be responsible or not. There will be some customer who was unaware about the quality of goods and all. There are customers with the imperfect recollection. So these are the questions that is to be answered by these giants like Amazon, Flipkart, and Google. Now again, we will discuss what is the objective of trademark law. So there are basically two objectives of trademark law. First is basically to provide the protection to the proprietor of any trademark. So the basic objective of trademark law has been explained by the Supreme Court in Dowdell versus State of Uttar Pradesh in the following words. The object of trademark law is to protect the rights of persons who manufacture and sell goods with distinct trademark against invasion by other person, passing of their goods fraudulently and with counterfeit trademark as those of the manufacturer. So this is basically the first function, to protect the proprietor of the trademark from the prospective infringers. And then in second case, Lakshmikant Patel versus Chetan Bhai Shah, in this case, the court held that the other objective of the trademark law is to protect the customers also. So obviously trademark protect the customer, because when you have the faith in any particular brand and trademark, you can buy it without any hesitation, because you have faith, because for a period of time they have developed their reputation and all. So in this case, the Supreme Court of India held that the law does not permit anyone to carry on his business in such a way as would persuade the customer or client in believing that the goods or services belonging to someone else are associated therewith. So the person, the customer, they should not be deceived. There should not be any you must have seen when you go to any market on online also, you will see the counterfeited products, or you will see the fake product like Abibas. In place of Adidas, will find Abibas. There is one slogan, Nike, just do it. And then I saw a t-shirt that is written Nike, just did it. So that is basically, again, they are what they are doing, they are deceiving the customer. So that is the another objective of trademark, that the person, the customer, they should not get deceived by the infringers, or the infringer, they should not be able to pass off their goods by showing that they are the goods of somebody else. So based on this, there are some cases like Google versus Louis Vuitton. Now, Louis Vuitton, it is a French company, very famous company. It has registered trademark in different countries. Now, what happened when you search Louis Vuitton? Now, it was found by the Louis Vuitton that when they will search it on the Google, it will take you to the site of Louis Vuitton, but then there will be some sponsored links. There will be some keyword. It will take you to the another site. So whenever you open the Louis Vuitton, the page will open, and there will be some sponsored site. When you click on those sponsored site, it will take you to the page which is selling the imitation of the Louis Vuitton product. So this Louis Vuitton, they filed a suit against the search engine Google. But the court held that, the European court held that the search engine operators such as Google do not themselves infringe trademark right if they allow advertiser to use a competitor trademark as a keyword. So in this case, it was held that the Google, they will not be responsible. So, but basically the opinion was, unless the Google is directly involved in that, they will not be responsible. Then in other case, the Cosmetic Warriors Limited and Lush Limited versus Amazon Company, UK. Now, in this case, the United Kingdom High Court, Amazon were found liable for. Now, in this case, Amazon was found liable for the infringement in the use of trademark, which trigger links to its website and did not encompass the branded product reference, such that the consumer could not tell whether the product on sale were those of the brand owner or not. So in this case, because the Amazon, in this case, it was held responsible because it could not able to tell the goods that the buyer is buying, whether it is related to the owner of the goods or not. But then in L'Oreal versus eBay, again, in this case, it was held that the company eBay will not be responsible unless it is directly involved. So which in this L'Oreal versus eBay, which concerned the sale of counterfeit goods on eBay online marketplace, similarly held that eBay would not be liable for trademark infringement unless they were actively aware of the infringing activity. So again, this is the problem. Like it will give you the suggestions. It will give you the fake sites which are selling the imitation of the original goods and product. So this is how it is conflicting with the trademark law. So in conclusion, finally, I will say that the situation reminds me of the adage that the one can like it or may dislike it, but one cannot ignore it. So you may like artificial intelligence, you may not like artificial intelligence, but you cannot ignore it. So because obviously we are using artificial intelligence in day-to-day activities, and like 2030, around 75% of the organization they will be using the AI. So whether we like it or not, but we cannot ignore it. So in conclusion, the evolution of artificial intelligence will undoubtedly affect every facet of the legal field, and the trademark law is going to be no exception. Thus, there is a constant need of amendment and development of the legal structure so that trademark law does not merely turn into a repository of loopholes that cannot sustain trademark claims. So, obviously, we are developing AI, but at the same time, we have to keep in mind that we should amend, we should replace the laws of the trademark law so that it cannot become redundant. Thank you very much.
Thank you so much, sir. I'll just ask all the attendees if they have any questions, kindly post it. Sir, with your permission, I will read out few questions.
Yes.
So one of the questions is by Anushka Joy. It reads that, are there softwares to detect that any text matter has been generated by AI?
Right now, there is no such application as such, because obviously they will give you the answer on the pre-fitted data. So whatever you have feed in that application, it will give you the answer on that basis, and you cannot like recognize, like we are saying, this is basically the difference between Chat GPT or the Google. The Google will give you the source from where they are taking any particular article or any reading and all, but Chat GPT, the application like Chat GPT, they will not give you any source, so you will not be able to like know from which source this message is coming.
Right. And sir, I think that is also a difference between, like, we have Google Bard. I think it gives the source from where it is copying that kind of information, while Chat GPT does not do that. I think it's more like a generative AI where it's generating its own answer. Right. So there's one more question by Shreya Nayak. Can there be role of CCI, Competition Commission of India, in manipulation of competition as market is involved when certain recommendations are made by AI?
Yes, it can be done, because like, as you know, artificial intelligence, like I read an article which says that artificial intelligence is just like a 9 years old child. So it is developing. So by the time it will become an adult, you can say like there will be some regulation by the Competition Commission of India. So yes, it can be done. Like in some countries like America and even India, they are thinking of banning this Chat GPT, because what the people they are doing, they are using the Chat GPT in their dissertations, in their even in PhD thesis. And there was 2 example where question paper of MBA and 3 set of question paper of law, 4 set of question paper of law. It was given to the Chat GPT, and it answered correctly. It scored B grade in MBA's question paper and C grade in law question paper. So yes, there can be, obviously there should be some regulation, otherwise it will become uncontrollable.
Thanks, sir. But if you have any more questions, kindly post it on the chat box. And sir, if in the case of the one that you discussed with respect to Louis Vuitton, I think in that again Google is just an intermediary in that sense, that
Yes.
it is facilitating a platform,
Yes.
or it's just providing a platform. So I think in that case there cannot be any imposition of any obligation, or for that matter any legal obligation on Google,
unless they are like intentionally they are involved in any links and all, they will not be responsible. Yes.
Yes, sir.
Any other questions?
Sir, I think Richa ma'am, can you see any more questions? Okay, yes, ma'am. Yes, sir. There's one more question. In regard to product packaging, what is the concept of trade dress law?
Packaging, basically, if you see the definition of trademark, it says that the trademark means a mark which can be presented graphically and which should be able to distinguish the goods and services of one person from those of another. And it can include shape of goods, their packaging, and combination of color. So even the packaging, like even the packaging and all, it can be covered as a trademark. Now, trade dress, basically, trade dress is, if you have seen that toothpaste Colgate, that is basically the trade dress. They're using the combination of color and all. So it can also be protected as a trademark, provided it has the acquired distinctiveness. There are two distinctiveness. One is inherent distinctiveness. There's a mark which is inherently distinctive, like Nike, Adidas. They are inherently distinctive. But there are certain marks which are not inherently distinctive. They can have the acquired distinctiveness. So by use or by their reputation, they will become famous, and then they can be protected as a trade dress.
All right. I think all the questions have been answered. Richa ma'am, any more questions that you can see maybe on the chart?
No, I can't see any questions on the chat. But all I could say is, after listening to Sir's talk, that AI is here to stay. There's no denying the fact. And then AI is also here to manipulate us.
Yes.
It
To be
is.
honest, it was a new topic for me also, and for the last 4 and 5 days, I was reading this AI and all, and I think it is very interesting. Even though I think even after this value-added course, I will work on this AI and all. So I am thinking of writing an article on this. I think it is a very good topic that has been taken by you all.
Yes, sir, because at times we do feel that yes, AI is like there had been a question also wherein the participant has asked that what action would be taken if AI is manipulating us, like the kind of suggestions which we see whenever we shop. The online shopping is the currently we are doing online shopping, and there all the suggestions are being suggested by AI only, right?
Definitely.
So, at one hand, we do feel that it is manipulating, but at the other hand, it is also making it easy for us,
Yes, yes.
getting the same kind of suggestions as we want to have. So, I think AI is here to stay, and balance is the key. Like in one of the lectures, one of the speakers stated sustainable development. So, we had been talking about sustainable development in environment. Now we will be talking about sustainable development of AI.
Yeah, yes, yes. So like same thing, like I said, you may like it or you may not like it, but you cannot ignore it.
Yes, that's the correct thing, that you cannot ignore it.
And sir, you rightly mentioned that when you were discussing the disadvantages, that unemployment is one of the issues.
Yes, yes.
But we do not know what is, that is.
It will take.
It can create employment. We never know. The
Yes.
same analogy that you made with internet, when internet came, it was that it will take up the job, but it also has made our lives easier.
Easier, yes.
So
again, both advantages and disadvantages are there. It will take your jobs, but it will provide you the opportunities also in the coming future.
Right.
And the same kind of fear was there when there was industrial revolution. With the advent of machines, we felt the same, that people will run out of employment. But it generated employment as well.
Yes, at the time of invention of the computer also, we were fearing that it will take the jobs. But then later on, it provided millions of jobs. So obviously, it is uncertain. We cannot say whether it will take the jobs or it will provide the new opportunity. So that is uncertain.
Yes, sir. And it is also this kind of uncertainty is also because it's so new. And it is changing every day. Suppose if something like Chat GPT, even though AI had started that development, that we knew AI, but something like Chat GPT would also be there. is something, and even that is at its very initial stage. So for it to where it will
There's a
reach,
tug of war
where it
going.
will take us.
Yes, definitely. And there is a tug of war going between these two giants, Google and Microsoft. Microsoft, they are investing in this ChatGPT. They have already given 1 billion in 2019 and then 10 billion in 2023. And then this Google, they are also developing their AI-based application BART. So there is a tussle going on between these two giants.
Right, sir. Rightly, sir.
I'm sorry, from Monday the session is starting, so some must be understanding. The students have started coming in.
Okay, okay.
Yes, ma'am.
So it is like balancing both the sides right now.
Multitasking. You are
Multitasking. So
doing
true,
like a
sir.
strong AI.
That's so true, sir. So true. But thank you so very much, sir. It was quite an interesting session talking about trademarks and trade dress and AI, how AI is impacting this particular domain of IP had been really interesting to listen to. And I think even the participants will concur with my opinion, and they must have felt that artificial intelligence has been playing a role and is going to play a bigger role when it will come to the product, whether it is product consumption or whether it is product designing.
Thank you so much. And I must tell you that initially, like, I was not able to understand how I should relate AI with the trademark, and all. It took me 3 days. And then finally I was able to connect the AI with the trademark law. So I really thank you for giving me this opportunity, and I really I must appreciate the topic that you have selected for this year value added course. Thank you very much.
Thank you so very much, sir. Thank you.
Thank you so much, sir. Thank you very much.
And at the end, I would like to thank Priyanka ma'am for the wonderful moderation that you have done. The moderator makes the session so very interesting. The moderator is the one who binds everybody together, be it the speaker, be it the participant. So thank you for carrying out that work so well. And
Thank you so much. Thank you so much, ma'am.
And
And
I hope we'll be doing much more programs like these later on.
surely, ma'am, surely.
Okay. So thank you,
Thank you.
participants, for being there throughout and being such supportive and participative participants. So we will be sharing the feedback link after some time. You all are requested to fill in the feedback form. And then tomorrow we will meet with new sessions and much more interesting sessions. And please do remember that there will be a valedictory from 3 o'clock, which is mandatory for all the participants to attend. Thank you so much. Good day.
Thank you.
Thank you.
Thank you, sir.
Thank you, ma'am.
Thank you, ma'am. Take care.